the first meeting and the only meeting for this interim of the Disabilities Concern Subcommittee of the Legislative Health and Human Services Committee. And I'd like to go ahead and call the meeting to order and then take roll call. Peter, do you do that? Well, let's go ahead and just do introductions, and then we can, since there aren't that many of us, we can, make sure that we have the quorum. I am not seeing people. I don't know why. You know what?
There's a section or a little button that says participants. If you click on that, it'll display everyone who's on the panel list.
Okay, wonderful. But I mean, I'm not seeing the video part. I think it might be because I came in under Peter's email address. So let me see if I can get that. Well, you're not in view, Nancy. Okay, I will work on that.
Do you have the little squares?
Yes.
And clicking on that doesn't help?
Yes, I did it. Thank you.
Okay.
I tried that before, but it didn't. How are you, Senator?
Good to see you. Yeah, it's crazy. These little, I just click everything and sometimes I kick myself off.
Well, let's hope I don't do that. So let's go ahead, and would you like to introduce yourself?
Sure. I'm Antoinette Cedillo Lopez, and I represent pretty much the university neighborhoods, Northeast and Southeast Albuquerque.
Great, thank you. Let me see. Our vice chair is Senator Nancy Rodriguez. Would you like to introduce yourself?
Thank you, Madam Chair, and thanks for introducing me too. This is Senator Nancy Rodriguez, and I am the vice chair this year, our great representative for our ENI alternate every year. And this year I'm the vice chair, and she's doing a great job as the chair. So thank you. Happy to be here.
Thank you. We'll continue down the senator side of the legislature. Senator Padilla.
Thank you, Madam Chair. First time I've attended this committee since I've joined the Legislative Health and Human Services Committee. I do serve on the behavioral health side of it. I represent about 85% of the southwest quadrant of Bernalillo County, and I find myself, Madam Chair and Madam Vice Chair, more and more moving in this direction with my legislative work because of stuff I do with CYFD. I've done a lot of reform and a lot of work in that area in early childhood. So I appreciate you allowing me to join you today, and I look forward to the agenda. Thank you.
Thank you. And on the representative side, Representative Thompson.
Thank you, Madam Chair, and good morning, all. I'm Representative Liz Thompson, House District 24, Northeast Heights of Albuquerque. And in just a few short weeks, I will have been a practicing pediatric physical therapist working with kids with disabilities for 36 years. On October 1st, it'll be 36 years. So, and I also have an adult son with significant autism. Thank you, Madam Chair, and I'm looking forward to today.
Thank you, and you'll be one of our panelists later in the day. And we have one of our newest Representative Black.
Thank you, Madam Chair. I am Representative Black. I serve District 51, which is in Otero County, the big city of Alamogordo. And I'm glad I'm part of this committee. Thank you.
Thank you. Just over the hill from the Oregon Mountains.
Yes.
So welcome. And also our newest legislator is Representative Lujan.
Good morning, Chair, and good morning, committee. Representative Tara Lujan, House District 48, Santa Fe County. Just a diverse county, and my bandwidth doesn't support my video, so I just went out again. So happy to be here. Thank you very much. I'm very not just interested, but disabilities has affected my life. And so I'm very, very happy to be part of the discussions and the committee today. Thank you so much.
Thank you, and good luck. You're doing a great job. So thank you all. And then we have a lot of people who are watching, and we hope that they will.
Madam Chair.
Oh, I'm sorry. I didn't see your name, Representative.
Madam Chair, this is Miguel.
Yes, sir. Go ahead.
Madam Chair, top of the morning to you all. I'm participating via the telephone all day. I'm State Rep Miguel Garcia. I'm finishing up my 24th year in the legislature. Fortunately, I got reelected again. I represent some of the more historical areas of the city of Albuquerque and the unincorporated area of Bernalillo County, starting with the South Broadway community on my eastern boundary. South Broadway basically started as a part of the railroad community, but it also involved the first entry of our Afro-American residents into the central part of New Mexico. So it was a hub of kind of Afro-American neighbors for the longest period of time. Also, we crossed the railroad tracks and we're in Old Barelas. Barelas established as a Spanish villa back in 1750 of residents from Old Town Albuquerque and from where I live here in Atrisco, across the Rio Grande. And then we crossed the river and we're in Old Atrisco, established in 1692 as a Spanish land grant by my great-grandpa to the sixth power, Fernando Duran y Chavez. And we keep moving west and we cross Old Coors, south of Central, and we're in a kind of a blue-collar Chicano neighborhood known as the Alamosa community. And then I have a couple of West Side precincts, kind of gated communities, mainly made up of lower middle class, middle class, Native Hispanics, and also first generation Mexican immigrants. And it's an honor to be part of this committee. I've been in this subcommittee for a number of time, for many years. And I really enjoy the topics and the leadership that this committee has had historically. Thank you, Madam Chair.
Thank you, Representative. Is there anyone else on the phone? Okay, great. So our first panel.
Madam Chair, can I just have a tiny point of privilege? This is Antoinette.
Yes, of course.
Representative Garcia, you said Fernando Duran y Chavez was a great grandfather to the sixth degree.
That's correct.
My grandfather to the seventh degree was Pedro Duran y Chavez Otero. So we're going to have to talk.
Sounds like a generational battle.
Pedro Duran y Chavez was the father of Fernando Duran y Chavez. So Pedro was
and he's my, that's so interesting because it's seventh degree for me. So we'll have to talk. We're very, very distantly related, I think.
Okay, prima, we'll talk.
Okay.
That is so cool. So yes, let us know how your genealogy works out. It's, your trees and branches can join. So our first panel is on supported decision-making in lieu of guardianship and conservatorship. Sorry, it looks different when you have to read it. And we have our Executive Director of Developmental Disabilities and Planning Council. We are so lucky to have Alice Lou McCoy. And also Pamela Stafford is with the Public Policy Director of the ARC of New Mexico. Both very experienced people, and we are so glad to hear from you. So do we have things ready for your presentation, Ms. McCoy?
I believe so. And so do we share the screen ourselves, or does Peter have the presentation, the PowerPoint slides? How does that work?
I know we have them. Let's see.
I can share them. I just
Nancy Rodriguez, can you share them, please?
Martinez.
Yes.
I have them up, so I can.
She could share them up to her.
I'm happy to share.
Okay, if you can share, go ahead, and you have
Absolutely.
control.
Okay, great. So I'll do the slides for you, Pam, unless you want to do it yourself. That way we just have one person doing slides.
I think you're starting at the end.
There we go. Good morning, everybody. Thank you for having us this morning. I'm going to let Pamela start. Thank you for the great introduction, Madam Chair, and so happy to be here, members of the subcommittee.
Welcome.
Thank you. Is
Pam unmuted?
She is unmuted. Let me see, we're having trouble. I can hear her mouth moving or see her mouth moving, but I can't hear her. And then also, okay, Pamela says, let me check the chat. Let's see if she's, Pamela, can you chat to us since we can't hear you?
There's also a drop-down menu under mute. I don't know if there's probably.
Oh, am I muting? That's not. Oh, for Pam.
Can you hear me?
Yes.
Yes. Thank you for the information on the drop-down menu. That was very helpful. Madam Chairperson Alice, members of the committee, I am very honored to be invited to share my information on this panel. Talking about supported decision-making, first wanted to begin with a definitional approach to understand that when you're talking about guardianship, that's a legal relationship, and it takes away all a person's rights to make their own decisions. It gives legal authority over to another person. Supported decision-making allows an individual to make their own decisions, but with support in making those decisions and in communicating those decisions to others. In supported decision-making, the individual retains all rights and makes their own decisions. Ready for the next slide, Alice? So some trends in supported decision-making. As of May 2019, 9 states had enacted supported decision-making agreements by either statutes, codes, or practice. 6 states had pending statutes, codes, or practices. And across the U.S., more states are recognizing that this is the least restrictive ways to support individuals with disabilities or the elderly with diminished decision-making capacity. Next slide. And it has a great endorsement from national organizations, including the National Guardianship Association, the Social Security Advisory Board, and the American Bar Association Practical Tool and Resource Guide. Because there's not a unified code regarding supported decision-making, every state is doing it a little different. And so part of the questions that we have to ask in New Mexico is, what is the best approach for New Mexico? When does supported decision-making need to be formal instead of informal? Most of us, whether we have a disability or not, probably have people who help us make decisions informally. What decisions need to be formally implemented? In what cases is it better to have paid versus unpaid supporters? What mechanisms should be set up, if any, to pay for corporate supporters? Some states require background requirements for supported decision helpers. Other states do not, because that may restrict family members from being involved. But then how do we safeguard against abuse, exploitation, or undue influencers? Should there be court oversight, especially when offered as alternatives to guardianship? So, for instance, if you have a situation where a person has had guardianship, and this is seen as a step-down method before you remove all oversight, should there still be a status hearing by the courts? And are supported decision-making agreements enforceable, and do we want them to be enforceable? Those are some of the outstanding questions that I don't think we really have the answers to what would be best for New Mexico yet. Next slide. So some examples of some social supported decision-making agreements. Texas was the first state to implement supported decision-making, and it has a form which is basically a page and a half. The New York formal agreement is far more complex. I think it's up to 36 pages now, and it includes a monitor who is not part of the supported decision-making team, is court-appointed, and is specifically monitoring for financial abuse. So we would want, I think, somewhere in between. In 2018, as Senate Bill 19 was passed, which modified the Guardianship Act. It formalized the requirements that courts consider alternatives to guardianship. The first draft of that bill included quite a bit about supported decision-making, but that was removed from the final bill. So at this time, there's no actual established practices or guidelines for how New Mexico provides supported decision-making. And so there's no formalized supported decision-making in the state of New Mexico at this time. And I'll turn it over to Alice now to continue.
Thank you, Pamela, for that really great introduction to supported decision-making. I guess you all are wondering, why are we even talking about this? Why is this so important? And I want to start with a broader view of where supported decision-making fits in the greater scheme of decision-making assistance. So for those who don't know, the Developmental Disabilities Planning Council runs the Office of Guardianship. And at the Office of Guardianship, we get calls all the time for guardian help and some kind of help for an individual. So even though every call we get is not appropriate for guardianship, because as Pamela said, guardianship should be a last resort option because it does legally remove the right to make certain decisions based on what the court has determined, you're incapacitated to make. And so for folks who do need assistance but are not appropriate for guardianship, there's not a whole lot out there for assistance. So let me just go over what options we have in New Mexico. There are what we have traditionally thought of as alternatives to guardianship, for example, powers of attorney. We have healthcare surrogates here to help you make healthcare decisions. We have representative payees whose responsibility is to manage your Social Security income. Those are appointed by the Social Security Administration. And these first three options, the individual may choose these people. And so there is a level of choice. For powers of attorney, for example, an individual may say, this person is allowed to make, for example, financial decisions on my behalf. For healthcare surrogates, obviously those are healthcare choices. And then for rep payees, once you've named a rep payee, that person has sole responsibility for helping you manage your Social Security income. But in all of these options, you've given your choice. I mean, you've chosen the person, but then after that, the person does have the power to make that decision for you. Supported decision making is a different breed from these alternatives, because you still retain the right to make the decision on your own, and the supporters around you help you understand what the decisions mean. You have the capability to understand, you just maybe need some interpretation, or maybe you need some explanations for the consequences of your choices. And as well, the supported decision-making supporters are there to communicate your choice once you've made it. So maybe one of the reasons why you may be considered incapacitated when you really are able to understand your choices is maybe you have trouble communicating your choices. So you may be appointed a guardian to do that for you. And so supported decision-making really opens up the universe of how you can navigate the world and what decisions you can make. We don't have this in New Mexico. So this is what I like to call the ladder, right, of decision-making assistance. The next step in this ladder are protective arrangements. We don't have this in New Mexico, at least not for guardianship. Conservatorship is another story. Today we're just speaking about guardianship. And so for protective arrangements, it is a court-ordered arrangement, but it's sort of a one-off type of situation. So maybe you are a person who, so this fact pattern comes up in my Office of Guardianship quite a bit. So maybe you're a person who may be temporarily incapacitated. Maybe you're in a coma, and there needs to be there needs to be a decision made on, a procedure that you might need that will drastically improve your outcomes. But you cannot make that decision because you're incapacitated, you're in a coma, and there's no other person who has the authority or power to do that. That's a really great time to go to the court for a protective arrangement. Instead of putting you in a guardianship, for example, that may, once you come out of this state, you're still stuck in that guardianship. In a protective arrangement, it lays out very clearly here is the kind of decision that this person can make. So it's, again, like a one-off situation. This is also not something available in guardianship that we have. What we have moved more toward, and one of the things the Office of Guardianship is doing, is changing the culture of guardianship so that instead of what we call a plenary guardianship or a full guardianship over somebody, we're moving more toward a culture of limited guardianship, because people who may be held incapacitated by a court, there's a broad range of what folks are capable of, what individuals can do. And very rarely is a person completely incapacitated. They may be able to make decisions about, who's coming to visit them or where they live, but maybe they need assistance with their finances or with healthcare decisions. And so in limited guardianship, and I believe the courts are also moving this direction, the order specifically states what kind of authority and what kind of decisions your guardian can make on your behalf. And so it is, that's why it's called a limited guardianship. The authority of the guardian is limited to certain kinds of decisions, and you retain the rights to make decisions about everything else that's not set out in the order. So we're moving more toward that model here in New Mexico, but it doesn't go far enough. And of course, conservatorship and plenary guardianship takes over all control over all the decisions. So in conservatorship, that's the entire control of your estate. Conservatorship is usually reserved for people who have substantial assets and need a specific financial decision maker to help them manage their financial assets. Plenary guardianship is a guardian who basically has the final say in everything to do with your life. The only right that isn't that nobody has any say over except yourself is the right to vote. I want to go ahead and emphasize that, because I hear this misconception a lot, and it is election season coming up. So the right to vote is retained by every single person, but in a plenary guardianship, every other right can if the guardian decides is not in your best interest, it can be taken away. And so, as you can see, there's a really big gap in our ladder of decision-making assistance. You have sort of this, ad hoc, these alternatives that are in place that kind of help you with, this or that, but doesn't really give you a comprehensive support system, or you're giving up rights. And so there needs to be something in the middle. It's greatly needed in the state. And so I want to go into a little bit about why New Mexico really needs supported decision making. I think, one of the principles I've seen that really hit home for me is that the right to make decisions is a human right. And in fact, the Human Rights Commission, excuse me. So it is an internationally recognized human right. So the UN Commission on Human Rights has, years ago recognized that this is a really important issue for us to look at. And disability rights is probably the very last frontier of civil rights work that still isn't universally recognized as a civil right. If you think about just yourself and all the decisions that you make every day, if even one of those decisions about a major life situation was taken out of your hands, think of how powerless you would feel about that. And so, for example, where you live, what kind of procedures or what kind of treatment you're allowed to get, what you do with your paycheck, all of these things can be taken away from you in guardianship. And in the UN Human Rights Commission, they very specifically made a statement that said we all need to move toward supported decision making as a first step, or as the default, right, when folks need assistance making decisions. That's not to say that guardianship isn't appropriate at all. It is. Guardianship is a very, very important resource and a very important avenue of assistance that we need to have available for folks who really need it. And but we need to be more careful about who guardianship applies to and who really needs that level of support. And one thing we see is that there are New Mexicans living with developmental disabilities, mental health challenges, aging issues that are disproportionately affected by the lack of this kind of scheme available, that goes straight into guardianship. So an example is, let's say you're a child or maybe a young adult who isn't of age yet, who has a developmental disability. And you turn 18, and the school tells your parents, well, nobody can help this child unless you become that person's guardian. And so now you're stuck with a guardian, and maybe your parent doesn't even want you to be a guardian, or doesn't want to be your guardian. Maybe your parent wants you to grow up and be an adult just like everybody else. But you're stuck in this guardianship situation because there's a misconception that if you're a person with disabilities, then once you become adult, you need to have a guardian in order to get the support that you need. And so this happens all the time in schools, where schools tell parents, you need to become this person's guardian. What's true is that that individual, that young adult, may need assistance helping with making decisions, but not a full guardian. And so what are the options they have available? Not a whole lot. And so this does, disproportionately affect folks who are trying to grow up, become full adults to the best of their capabilities and abilities, and don't have, a scheme of doing that. Also, folks who are living with fluctuating capacity. So, two populations that come to mind: New Mexicans living with mental health challenges and may be dealing with issues as they age. And so, again, guardianship can be very helpful and appropriate in some cases, but in many of these cases, people do have fluctuating capacity. So what do you do when you have a guardian, but you mostly have capacity, except when you have, for example, in mental health challenge, you may have periods where you are incapacitated because because of your mental health diagnosis. So what do, you know, when most of your life you can make decisions, you do understand what you're doing, but you have this guardian who is basically running your life. So these kinds of issues come up over and over again in guardianship, and it's very burdensome on the system. It's burdensome for the guardian, it's burdensome for the courts to go back to the courts all the time, back and forth, to try to figure out what level of support this person needs. And it's, you know, it's expensive as well. And for the Office of Guardianship, we, you know, we pay for legal services, we pay for the guardian. And so, oh, that's the next point I'm making. So we have very limited resources as a state, as you all know. And at the Office of Guardianship, our wait list is growing exponentially. You know, between the rapidly aging population, our pandemic, which has made medical emergencies even more urgent. And then, of course, we see that our state funding is being slashed. The vast majority of Office of Guardianship spending is our general funds. And so we have to be very careful about how we distribute those resources. And so if folks don't need to be in guardianship, and there are folks who do need guardianship, you know, we want to make sure that people who need to be served are, and people who are not being served are not only stuck in a guardianship that they don't need and is hampering their ability to live their lives, but also, you know, it's wasting resources. So we want to be a lot more precise about what level of support we provide to folks seeking assistance. So at the current level of guardianship in New Mexico, the courts only have the ability to review guardianships once every 10 years. They can review guardianships forever, so not the ability, but they have the requirement. I'm sorry, I misspoke. So courts have the requirement to review guardianships once every 10 years. You know, there's been consideration about changing our statute to require courts to look at guardianships more often than that. But the reality is that courts also have limited resources, and there are, you know, almost 6,000 guardianships here in New Mexico. If judges were required to do more than once every 10 years, it could overwhelm the court system. And, you know, that isn't great either. So you may see individuals stuck in guardianship for longer than necessary. And if you're a person who is paying through private pay for your guardian, that could unnecessarily waste your estate or, you know, spend down your assets. Or if you're, you know, using state resources, if you're one of the Office of Guardianship's clients, then, you know, we are using resources for a guardianship that's not necessary when we have a huge now wait list. I believe we're definitely over 100. You know, we might be. It's pretty high. So I don't have an exact number right now, but it's really high and it's rapidly increasing. So there are folks who are waiting, and, you know, we're still processing emergency cases, but we really have to hold. You know, for our FY22 request, for example, the Office of Guardianship has a shortfall of almost $1 million, and so we are really looking for ways, and supported decision making is one of them, to be, again, like I said, more precise with the level of support we're giving folks. So finally, you know, the major thing that we want to avoid, of course, when we help people or not help people into guardianship, is when we have folks who are not appropriate for guardianship, we don't want to just leave them without any help. You know, there are, again, ways for us to refer folks to different resources to, for example, get a power of attorney in place. Maybe you just need a rep payee, or maybe we can give your family some technical assistance about what kind of supports they can look for or put into place for you. But many times people are contacting Office of Guardianship because they don't have that kind of family support. They don't have a strong group of people who can help them do the things that need to be done to run their lives in a safe and healthy way. And so, so folks who don't have that ability, maybe they are in a facility and the facility is calling us for assistance, you know, they may end up in a catastrophic situation. You know, they may end up in acute inpatient care because there isn't that kind of support available, and yet they're not eligible for guardianship. And so, again, we need to fill in the gap of the latter to make sure that folks who do need guardianship get it, and the folks who don't need guardianship have the right level of support that they need, that they're surrounded by that people who can help them get where they need to go, take care of themselves, but who have the ability to make their own decisions. Last year, or I guess earlier this year, in the 2020 regular session, House Memorial 23 and House Bill 67 was passed to form a task force. And the task force was, the purpose of the task force was to study and report on supported decision making. And some of the questions that Pamela discussed earlier and some of the issues that she discussed, those are the kinds of questions and issues that this task force would be studying and reporting on. This task force is incredibly necessary. It's not, in order to put supported decision making into place, we either need some kind of legislation, which is the preferred way, or we need some kind of consensus among courts and other legal decision makers that supported decision making agreements are enforceable and are the right way to go for some folks who require assistance. The House Memorial and the House Bill never made it to the floor, so there was no decision made on it. But we're bringing it to you again because it is such important work that needs to be done. Because we believe legislation is the right way forward, we need to be very careful about what we're proposing. We need to, and recommending to New Mexico. We are a unique state. There are many states now who have studied and have implemented some kind of supported decision making, and some states who sometimes look very similar to us in some ways. For example, Alaska has done a lot of work on supported decision making, and they are a largely rural area, big Native American populations. They have some of the same issues that we're looking at. So that's just one example of the many states that have already implemented supported decision making. We want an opportunity to tailor the approaches that other states have made. We don't want to reinvent the wheel, and we want to learn from their mistakes. A lot of states that have done supported decision making for a few years have, they've seen what the pitfalls are. They understand what works and what doesn't and why in their state, and we'd like to learn from them. So this task force is really important for us to do that. Even though we don't have the House Memorial or the appropriation to do this work, DDPC still wants to move forward with it. So at this point, we are moving forward with the planning process as far as bringing together a broad range of stakeholders. I've listed a few here, but we really want to involve the courts. It's necessary for the courts to get involved so that they understand what alternatives are available and they can help craft the alternatives, because courts, more than anybody else, they see what kind of cases come before them and what kind of issues require support that may not be eligible for guardianship. And so, of course, we want folks living with disabilities, the people themselves who are making decisions, who are utilizing these supporters. We would like to see legislators, of course, because without legislative buy-in, we're not going to get anywhere with supported decision making in the state. We would like experts on specific issues, especially on populations that are disproportionately affected by guardianship. So, as I mentioned before, experts on aging, on mental health, and behavioral health, and on developmental disabilities. And so what we're requesting today is that the subcommittee endorse a House memorial or a joint memorial for this task force during the 2021 regular session to prioritize the work of this task force. As you know, my agency is doing a lot of work out in the community, and it's important work, and we're really happy to do this work. And but we do have to prioritize what we do. And I believe that a House memorial from the legislature will give us the directive that we need to prioritize this particular task and this particular project. And of course, it would demonstrate the legislature's commitment to establishing supported decision-making in New Mexico. It is the it is the cutting edge of guardianship work. I've been saying that for a few years. So at this point, I'm not really sure if it's so much the cutting edge as a direction that many states have already begun moving toward. And I believe it is sorely needed in this state, not only to protect people's rights, but to preserve the resources, the very limited resources we have. So thank you very much for inviting Pamela and I to come speak with you. And we are here for questions if you have any. Thank you.
Thank you, Ms. Lou McCoy. We appreciate it. And Pam Stafford also. Are there any questions from the committee? I cannot see anybody. And
there are several hands up. This is Senator Stefanik.
On your participants list, Representative Ferrari, this is Senator Rodriguez. There's 4 of us, and so far that I can see.
I see. Thank you. I got it again. Yes, Senator Stefanik, I know you're just joining us because you were on the participants. Instead of participants, you were on the visitors. So would you like to introduce yourself?
Thank you, Madam Chair. This is Senator Liz Stefanik, and I'm very interested in this committee because I worked in a field with elders and disabled people for over 11 years. And I think this is an exactly timely topic, and I hope to ask a few questions in a minute.
Yes, would you like to go ahead? I didn't see how everyone was in order, so we'll go ahead and start with you.
Okay, I'll try to be brief. This year in particular, I've had 2 constituents actually get caught up in formal court-appointed guardians. And in one situation, the family and the individual were very unhappy and in agreement in working together. So I understand a need for this this middle ground here. And I'm wondering if the director, and it's great to see you, Alice and Pamela, I'm wondering if the director could let us know if you would be ready for a statute this year versus a task force.
Thank you for the question, Senator and Madam Chair. So I think it's important to have a task force because there's so many different ways to do supported decision making, as Pamela has reviewed with us. And I would be careful about whether or not what kind of statute, I guess, we want to put into place, because I don't want to put anything in place that is going to be unworkable or hard for us to implement. And then, of course, we'll turn everybody off of supported decision making and nobody will want to do it again. So I think it is important to do the task force. I understand the need is great, which is why, we've already started putting together the task force. We haven't been able to move forward with it this year because we have so many priorities with the pandemic in place and with other priorities that we're making. But again, this work is so important that we haven't stopped working on it. It just hasn't gone as quickly as I would like it to. And I believe this memorial will help us really jumpstart it and shoot it to the top as far as our priorities list. So the long answer to your short question, Senator Stefanik, is that I don't believe we're ready for legislation yet this year. As much as I hate to say that, I would love to put legislation in place this year. But I am open to being convinced otherwise. If there are legislators who have looked at this before, have studied and analyzed this before, and understand the ramifications of doing this in New Mexico. If they believe that New Mexico is ready, I am more than happy to have that discussion about this year, but it is not something that I personally have seen, and I haven't seen that we're ready yet here in New Mexico for legislation. But again, willing to be convinced otherwise.
So, Madam Chair, I bring this up because this is the long session we're going into. The following session, it couldn't really be considered unless it was on a governor's call. And if it did not make it, we would then be waiting. And my experience has been that oftentimes when we put out a bill with the, and I'm going to say skinny structure of what we're asking for, that it does take probably 6 months, a year, 18 months to even put all the regs and standards in place to implement it. So I'm just a little concerned about the lag time in pursuing something that I think is extremely worthwhile. And I'll be interested in listening to my colleagues about this. Thank you, Madam Chair.
Thank you. We also have Senator Ortiz-Pino joining us, and you have a question also if you'd like to introduce yourself.
Thank you, Madam Chairman. I'm Jerry Ortiz-Pino. I represent downtown Albuquerque, Senate District 12. It's the older neighborhoods in downtown, and it includes precincts across the river in the South Valley. And it goes all the way up to the UNM campus. It incorporates the main campus of UNM and part of the, I don't think the law school is in my district, but the medical school is. Madam Chairman, my question is actually I almost took my question down after Senator Stefanik asked hers, but I wanted to pursue it a little further. Even if we don't go for a statute for the supported decision-making this year, Alice, wouldn't it be good to go for an appropriation? Wouldn't it help if you had an appropriation? It gives it a little more weight. I mean, it would be a statute that would appropriate money to study assisted decision-making, and it might give you the resources to bring in some, if you needed them, some experts from NCSL or other places where this has gone on. I just throw that out as I'd like the idea of doing the study. I worry that sometimes memorials just don't carry the clout that even if it's a relatively small appropriation, that would do. What do you think of that?
Thank you for the question, Madam Chair, Senator Ortiz-Pino. So an appropriation would be helpful. I have not specifically asked for that today, but I am saying that the appropriation would be very helpful. I will say that one of the reasons why I don't believe yet that supported decision-making is ready for a statute, although again, willing to be convinced otherwise, is there are stakeholders in place that need to be on board. And the most important one being the courts, the Supreme Court of New Mexico. I have secured participation from the courts on this task force if it were to move forward. And so that's a really big help for us as we are, crafting support decision-making in New Mexico. Having the courts perspective and buy-in is incredibly important. I think will give a lot of weight to the work that we're doing. And again, I haven't asked for an appropriation, but it would be very, very helpful in the work that we're doing. Thank you.
And on that point, I'd just like to add, that's what House Bill 67, which died in finance, I believe, because of the funding. And then we went to a memorial, and House Memorial 23 actually wasn't able to be heard because of our time constraints at the end of the session. But that was to ask for the task force, and you've been able to start putting that together despite not having funding. So we really appreciate that. So I think what we need to do is, as you said, as legislators, to see what kind of support, and then how we outreach to go to the Supreme Court candidates who are now running and speak to them, and as well as those who are already appointed or elected. Let's see. Representative Lujan. Do you have a question?
Yeah, I do. Well, good morning. More comments, I think. Good morning, Chair, and good morning, everybody. excuse me, I have my, I'm going back and forth with my 6-year-old. We're doing some studying over here, but I just want to just support what Senator Liz Stefanik's laid out for you as far as like a strategy with how this could work going into a 60-day session and the time lapse that could happen. And also, thank you to Senator Ortiz Pino too. And I just want to say I support what they're saying, and just to give you some idea of, you have some support here. So I would really, really take that into consideration. And an appropriation this year is going to be kind of hard, but I think it's worth a try. And maybe, and anyone can correct me on this, but maybe even run congruently a memorial along with the bill, with the House bill, if that's the way you want to go. And I've seen that done, but it just gives you something, sort of a strategy of how to get this done through a 60-day session, so that we aren't waiting so long for the next session to come along. And like Senator Stefanik said, we'll be going into a 30-day, which limits a lot of things. So just want to say I support what they're saying, and thank you for your work. I think there's a lot of studies out there that are, and models that are already in place. And I have friends and family that are using those models, with working with family members with disabilities to give them the respect and dignity of making decisions for themselves. So thank you for your work, and I just wanted to make those comments. Thank you.
Thank you. Is there anyone else that I missed?
I do have a question and comments. Madam Chairman, Senator Rodriguez.
Yes, Madam Vice Chair, go right ahead.
Thank you very much. And I do recall this issue with guardianship being in the forefront of concerns and discussions for many, many years. I've been in the legislature now 25 years, and I can tell you that from way back, there were some concerns being expressed about guardianship and the need to make some changes. But it seemed like it was always a situation where it was too difficult to come up with any solutions, and that was not good enough. We needed to get this and finally work on it and do everything we can to make sure that people who have special needs and are, in need of guardianship would be well taken care of. And so while I was involved in this issue just a year, 2-3 years ago, I know that Senator Ortiz Pino was one of the gurus in trying to make some changes to the law and perfect it to the greatest extent that we could. It turned out that it was quite a bit complicated. It was not a simple issue as we think it is sometimes when we're looking at different provisions of the law. But one thing we do know, without a doubt, is that we cannot have a guardianship law that is actually continuing to take away the rights of a person who is in need and is incapacitated, cannot make decisions for he or herself, and just have the guardianship or the guardian all alone making those final decisions without sufficient oversight. I understand that the law that we passed recently made some changes, and certainly it's a great improvement. And thanks, as I said, to many who were involved incessantly trying to perfect that law. But there still is a great need to make some further changes. And I want to thank Alice and Pamela and many others for the work they're continuing to do on this. I like the idea that we can step out of the box, be open-minded, and look for other options other than, quote, guardianship. And I think that the idea of the supported assistance making is a wonderful idea. I did have just a couple of points I wanted to make on the potential for any legislation coming up or memorial coming up, and that has to do with the fact that, in an issue like this one, when there's so many facets to it, I think we probably need to bite the bullet, do legislation in the best way we can. We know we will strive to have a perfect bill, which is what we should be doing. However, with a situation like this, it is not uncommon that we would have a a bill passed, and then as time goes by, we would continue to make the changes that we need to perfect it more and more. But the time is of the essence. And every day that goes by, we have people that are needy, unable to take care of themselves without the proper care that they and security that they need to have. And so, you know, I like the memorial part too, because I want to see more people provide input, and we want professionals and people in the field come in and talk and give us some ideas and enlighten our mind, because we're not in this every day. We make laws, but we're not in the program every day. So we're open to hearing from the public and those that are professionally involved. However, I think that because it's a 60-day session, we will be able to have some input from people in committees and so on to be able to finally get a bill. The memorial is a good idea also to study it, but I agree with Senator Stefanik and even with Senator Ortiz-Pino when he mentioned, you know, about this, because it's good to have a memorial, but not. Again, because of the time, there's another 2 years of a lagging time there that people are just left out there without the support that they need. And so that's a great concern of mine. But that being said, Madam Chairman, I promise I'll be short, but I wanted to bring out maybe just a question to Alice, and briefly, if you can answer this, Alice, on the points that you made for the supported assistance, making the questions that remain that would have to be resolved, either for Alice or Pamela. On this financial abuse monitors that you mentioned, perhaps included in there, and I didn't see it on your list, but perhaps included in there would be the question of, you know, do these people, would they get paid? I know this was brought up on another one of your points, but on the monitors themselves, they would be outside monitors, so it would seem to me that we would want to look at, you know, them getting paid to be able to monitor this, and by whom, and how much, and, you know, that kind of thing. And of course, that would all be studied if we do the memorial or discussed in the bill. Another question would be, how about the possibility of giving priority to family members? I don't know that there is always a family member. I'm sorry, but my other lines are ringing while I'm unmuted talking here. And so, you know, that may be something to look at. You know, it doesn't always work, as we know, even from the issue of adoption or foster children and so on. You know, we look to family members first, but sometimes they're just not there, or whatever the situation is. So that's something, just a thought that came to my mind. And then, of course, you did mention about the agreements. Can they be enforced, and how, and to what extent, and then the court oversight, whether we would have that or not. There is a final point I want to make, Madam Chairman, that no matter what we do, we know that there has to be some form of oversight. This involves the estate of an individual who is fully incapacitated, and we must have someone not only helping and doing the guardianship and possibly the supported assistance, but also someone who can provide the oversight to make sure that we don't fall back into the same category that we've been for the many years past. So I really thank you, Alice and Pamela, for looking at all these options. You are truly very, very good at what you're doing, and I appreciate you very much, and I will be there in the forefront to help in any way that I can. Those of us that have had family members in situations that need assistance, I never have had one needing guardianship or assistance to that extent, but I can tell you that when you've been around not only family, but others who have special needs like that, you realize how vulnerable these individuals can be and how much they depend on someone like us to be able to take care of them. And I know that we're in this together to do our very best that we can. Thank you, Madam Chairman. Thank you, Alice and Pat.
Thank you. And Madam Chair, Senator Rodriguez, I'm going to take a quick short crack at answers to Senator Rodriguez's questions, and then Pamela, if you have other points that you want to add, and I'm sure you do, then please jump in. So very quickly, a few points here. So, anything is possible when we are crafting support decision making in the state. Who gets paid, what kind of system, if we have a monitor. And that's one of the reasons why we've asked for this task force to see if these are the right choices to make here in New Mexico. So, those are, there's no real recommendation right now because we haven't really looked at it. And we are, of course, dealing with limited resources. And if we did have, an outside monitor, would they be, a state-sponsored monitor? Would it be something that would be paid out of a person's estate? And, all of these considerations we'd have to think about for that. As far as capacity, this is only an option for folks who have retained capacity to make decisions. They just need the help of supporters to think through those decisions or communicate the decisions. So if you're a person who has who is completely incapacitated, this would not be an option that is appropriate for you. That guardianship really would be the better option. And because you've retained capacity, one of the things that the greatest thing about supported decision making is that you get to choose your supporters. So if you want your family members to be your supporters, yes, they get priority. So whoever you want to be the person helping you make specific decisions. So I'm just going to give you a quick example. I think this will help sort of fill in the pictures of what supported decision making could look like. And so supported decision making agreement, I'm just going to use the simple one from Texas. So in Texas, they have a form, they have, and it has an agreement, and it says, here's the kind of decision so financial is one, healthcare is another, there are some other ones. And so under each kind of decision, it'll list their supporters that will help them. And what the agreement does for the person is this agreement is supposed to be given to third-party folks who may be involved in your decisions. So, for example, if you have a supporter helping you make financial decisions, then you take your supported decision making agreement, you take it to the banks, right, and you say, "Here, banks, I need you to honor my agreement that my mom is my financial decision supporter, and I need her to be able to access my financial information. She needs to be able to take my financial information and review it with me so that I can make better decisions. And after I've made decisions, I need her to be able to communicate what my decision is to you, because maybe I'm not able to do that communication very well for whatever reasons. There are many, many barriers for those of us living with disabilities. And so so that's just one example of how that could work and what that would look like. I hope that kind of fills in the gaps a little bit about how why would we need this, how would we need it. And so again, as far as priority, the priority is the person's choice. Pamela, do you have anything else to add to that?
Yes, Madam Chairwoman and committee members, the points that have been raised to this time really indicate why it would be difficult to create a draft legislation at this moment. Is those questions related to who gets paid, who gets paid? Do you put a priority on things like credit checks, or do you put a priority on things like a monitor who is someone who the person trusts? All of those are questions that different states have handled in different ways. New Mexico's been through a lot in the last few years. And so the point I would like to most emphasize is that Senate Bill 19 of a couple of years ago really corrected a lot of problems and was an excellent bill in terms of guardianship. It is disappointing that so much of the abuse and financial exploitation actually occurred because of arrangements, and the people who were supposed to protect people are the ones that abused and exploited people. It seems to me, and the ARC New Mexico is one of the larger corporate guardianship agencies in the state, but it seems to us that the more we empower individuals, especially those with developmental disabilities, to have control of their own decision making with some support, and move away from the idea of putting in the power brokers, because absolute power corrupts absolutely. That the more that we can protect people by empowering them, and that's the idea behind the supported decision making. But there will always be a need for some people to have guardianship because they lack capacity. I hope that's helpful.
Thank you, Madam Chairman, and thank you, Pamela. It was very helpful, and of course, what Alice said was helpful too. You know, there may be a need also to work on language and provisions for the transition from the supported assistance to the guardianship, when people tend to be able to make decisions, and then at some point in their life are in the category of needing guardianship, for example. So all those things I do realize have to be looked at and studied. This is not an easy issue, obviously, for anyone, but we do know that we have to delve into it and do, as soon as we can, do everything we can to ensure that that these people are taken care of, that are needy and depending on us to do the laws to protect them. So thank you very much again for all your work. Thank you, Chairman.
Thank you, Senator. And next we have Representative Liz Thompson.
Thank you, Madam Chair, and thank you, Alice and Pamela, for your presentation. And I'm going to be, my husband and I have full guardianship of our son, and luckily that wasn't a hard decision. I mean, he does not have the capability, and I can't imagine being a mom of a child, and where you have, it's kind of on the edge, there. And it would be lovely if New Mexico had a full array of choices. And guardianship is expensive too. I believe when we did it back in, probably 11 years ago, it was upwards of $4,000 to do it. Because you need to have an attorney for you, an attorney for your child, a guardian. I mean, it's quite involved. So it's not like I'm going to snap my fingers and become my child's guardian. And I did chair the DDPC, I think from 2009 to 2012, although I could be wrong. And we had the guardianship program under that. And I'm kind of straying a little bit to say that we need to more fully fund the guardianship program. I mean, when I became chair of DDPC, it had not too long before guardianship had been with the Office of the Attorney General, and it really was the redheaded stepchild. No one wanted to take on the Office of Guardianship because it's a whole lot of work and a whole lot of costs, and without a lot of support from the state. So I'm throwing that out there into the universe to say we need to work on that too, because there are situations where full guardianship is required, and I think we need to really work on that. I'm torn. Because we do want to do it right, but we don't want to wait forever. And I will tell you, and having worked in the public schools for many years in special ed, I did run across situations where administration essentially said, this kid is turning 18. As soon as they turn 18, they are their own guardians, and we can just call an IEP and we can exit them from all services. And that is not what is best for the soon-to-be adult, I guess. I mean, it's still a child as far as I'm concerned. So that's something that's really scary for me as a parent and as a provider, that there are school districts out there who will take advantage of a student turning 18, if they're expensive or if they have behavior issues, because by law, kids in special ed can stay in school through the school year where they turned 22, which is what my son did. My son turned 22 in February, and he then left the program in May. So that's a scary thing for me. And then something I think about, and I'm assuming there's, you can do, I know you can do like financial, you can have oversight of financial over medical or whatever. But one of my one of the things that I think about is, when a child turns 18, and we know there's plenty of unscrupulous credit card givers and car dealers and things like that, where when you're 18, you can sign a contract that could put you in debt you could buy a timeshare when you're 18 and be in debt forever. So there's a lot of things that really make me nervous. And I think the idea of a memorial and a bill in 21 is an interesting idea. I'm not opposed to it. As someone said, is if we do a bill on supported decision making, is it going to be perfect? No, because they never are. But it would be great to have input from the communities that are involved. So I guess what I'm saying is I don't know what the answer is. I'm glad we have Alice and Pamela working on it, and I will join Senator Rodriguez that I will help you in any way I can. I will carry a bill. I will carry a memorial. I will try and get people together for listening sessions or whatever. But I think it is important, and thank you all for the work that you're doing and for bringing this to us so that we can start work. And bottom line is, if we don't get it done in 21, we could probably get a message from the governor, but dang, it's hard to get things done in 30 days. Although who knows what especially our Senate is going to look very different. And we're gonna be different in the House too. So maybe we'll become totally efficient and that nothing will die due to lack of time. Haha. But wishful thinking. So thank you, Madam Chair.
Thank you. Did either Alice or Pam want to respond? Okay. Thank you, Representative. Senator Antoinette Sedillo Lopez, you have a question.
A little bit deeper. One of the points that has been made over and over again is about corruption in this process. And what I've seen is when decision makers act alone, there's more potential for corruption. And so I like the idea you're talking about in terms of separating the financial from other kinds of decision makings so that there are checks on each other. But what are the ideas? What are the ways in which the supportive decision maker has been supervised in other states, other examples? Because I think that's critical.
Thank you for that. So the supported decision-making scheme doesn't give any decision-making authority to the supporters. The supporters are simply there, and sorry, thank you, Madam Chair and Senator Sedillo Lopez. I just jumped through into the answer. But the purpose of the scheme is to have a network of supporters to help you understand your options and to help you understand what you're getting into. You make the decision, and then if you need them to, you can have them help communicate your support. Now, that doesn't mean that in that whole scheme there isn't lots of potential for undue influence and that kind of thing, right? So I think so when you're that's one of the reasons why we want this task force, is to study how other states have handled that kind of thing. These kinds of questions will come up, Senator and Madam Chair. These kinds of questions will come up in committee from really sharp attorneys. For example, I brought up supported decision making several years ago to the, at least a couple of years ago anyway, to the Supreme Court legislative steering committee on guardianship and conservatorship issues. And at the time, I was an attorney at Disability Rights New Mexico, and I brought my proposed ladder of services to the Supreme Court steering committee to consider. And on that steering committee, there were legislators, there were obviously judges, justices, there were other stakeholders, like from the Attorney General's office, from the State Auditor's office, from the Administrative Office of the Courts, just a broad range of folks sitting on that steering committee. And I got those exact same kind of questions, Senator, and there's no easy answer for that. And in order to sell a really strong statute that people can get behind, I think you need an opportunity to answer all of those questions. We're just, again, we're not quite there yet. Now, that's not to say that there isn't an opportunity, if there is a great interest in doing some kind of legislation, for us, to do a quick study and, do what we can, to kind of look around. But again, a really thoughtful approach, and a one that the important stakeholders like the courts can get behind would be doing this task force, because they would be a part of crafting this system. And these are the kinds of questions that they for sure would be able to think about, consider, and have a recommendation for the legislature as to how we should deal with these kinds of situations. Pamela, do you have anything else to add?
I do. I do think that there is concern among some parents as well, that if they're not guardians and their adult child can decide who helps them to make decisions, that there may be the possibility of some of these undue influencers coming in with bad intent. And I worry about that in terms of individuals who may not have family members, but may not be very forceful in terms of making it clear what they want. And so my best example from the brief time I was a guardian is being a guardian for someone that was a limited guardianship, having a phone call about her wanting to date, have people over to the home, that type of stuff. I didn't have responsibility for that, and said that the courts had decided that she had that I only could handle medical issues, and immediately to see her IDT team come together to start to put in restrictions. And I had to intervene and say, the courts made decisions here, and the fact that there's not a guardian in place for some decisions doesn't mean that the team becomes those decision makers. And as the medical decision makers, I can change team members if I had to. But to see that kind of immediate response for someone with IDD, it's a concern. And so how do we do some kind of monitoring? That would be something I think we need to consider. And part of the issue that the task force could help decide.
Thank you. I appreciate that. And you had answered, I very much, I'm impressed that you've already creating this task force. And I was going to suggest you make sure that the courts are on it. You're already way ahead of me on that. But another person I'd like to suggest is law professor Jim Ellis, who has spent his entire career working on these issues and is very focused on individual autonomy and decision-making, because that's the balance, right, is giving the individual autonomy while protecting the individual from exploitation. And I'm glad that they can't actually make decisions, but then that doesn't solve the problem of people with fluctuating capacity. I was thinking of a case I'm familiar with in which the individual seems to be have a new boyfriend. She's in her, I don't know what, like probably 80s, and has a much younger boyfriend, and is spending a lot of money, and the family is becoming concerned. And my whole thing is, it's her money; she should spend it however she wants. But because that's autonomy. But then the family is concerned that he might be exploiting her. And so, what is and the choice seems to be just full guardianship or nothing. And there could be some in-between thing, I think, because I don't think, I mean, my reaction to the case I'm familiar with was that money doesn't belong to the family. It belongs to her. And if she wants to spend it traveling, why not? You know, so it's very much depends on perspectives, right? And how much you value autonomy versus how much you want to protect the individual. And I defer to all of your expertise and to the expertise on this committee. I'm learning about it, and I certainly will be very supportive because I see the problem. And I actually support the task force idea because it is such a complicated issue with so many questions. And I agree. I think you have to get the courts on board because their role in it needs to be absolutely clear. I think that's what happened with the lack of supervision and the need to revise it. And so the courts need to have very clear responsibilities in this regard that would, like a 10-year review is simply not enough. And particularly when you're talking about fluctuating capacity. So I very much appreciated your presentation. And as I said, I would defer to the expertise, but I did have those questions. Thank you.
Madam Chair, may I make one last comment in response to Senator Cedillo-Lopez?
Yes, of course.
Thank you so much, Madam Chair. And thank you so much for your comments, Senator. I just had a couple of points I wanted to make. The first one is that, you know, obviously this is a very complicated, tricky issue. Guardianship has so many little pieces that are hard to track down unless you really take the time and work to do it. And I do want to say that especially when we're talking about children with this, or I guess families with children with disabilities, you know, as they're becoming adults, we want to honor the fact that, you know, the right to make bad decisions is also a right. So I will say that if my parents had a choice on whether or not they could be my guardian when I turned 18, oh, heck yes, be my guardian until I was 35. And so, you know, but, you know, I hear you on exploitation. That's why we have to be very careful moving forward. As far as fluctuating capacity, I've done quite a few presentations on support decision-making. One of the examples I give and why support decision-making could be very useful, for example, folks living with behavioral health or mental health challenges, is that there is fluctuating capacity, where there are situations where you really do lose capacity, but then you can regain it. So one way support decision-making can help is that there's two kinds of decision-making here, right? Supported decision-making, where you're the one making the decision and you have supporters helping you. And then what we know as guardianship and other kinds of substitute decision-making. So for substitute decision makers, the other person makes the decision, you don't get a say. And so in supported decision-making agreements, it can be flexible. You can build in triggers where, you know, you say, for example, if you're a person who is on medication for a specific kind of mental illness that you've been diagnosed with, if you stop taking the medication, you end up being hospitalized because of that. That could be a trigger in your supported decision-making agreement that says, now I have a substitute decision maker. And in the agreement, there has to be a clear place as well for that substitute decision maker's powers to end. So the triggering, you know, the second triggering event could be, you know, I've been on my meds for X number of weeks and I have shown, you know, X, Y, and Z, facts that show that I have regained capacity, that I'm stabilized, right? And then the supported decision maker no longer has authority. You regain your decision-making capacity. And so supported decision-making agreements can be very flexible, in my opinion, incredibly useful to folks who have fluctuating capacity issues. And so those are the comments I wanted to make. Thank you, Madam Chair.
Excellent.
Cedillo-Lopez.
Excellent. Thank you, Madam Chair. That was very helpful.
Thank you. And next we have Senator Michael Padilla.
Yes, Madam Chair, can you hear me?
Yes, sir.
Okay, thank you. You know, just several points during this conversation and this presentation, I did hear members talk about, you know, we should add additional funding and And I think that's a beautiful thing. I really do believe that, that's good. And the presentations were excellent, Madam Chair. And thank you, Alice and Pamela. I'm so thrilled that you guys are doing this work, and it's God's work in a lot of ways. But the question I had was really around kind of what the legislature is doing. Do you find that the data and information, well, I guess my first question is, do you find that more folks
Senator Padilla, you accidentally muted yourself.
Okay, is that better? Okay, I don't know what happened there, but what is the trend that more folks are finding themselves in this situation where they would need guardianship and they would need these types of services? And then my second question is around the legislature. Do you find that we are reporting out data, facts, trends, figures, et cetera, on this matter so that we bring the attention to the finance as an example to bring that additional funding that almost every one of the members of the committee, at least that spoke today, spoke of. So I was actually the sponsor of the bill that created the Developmental Disabilities Planning Council Fund a while back. This would have been 13 or 14, I don't remember now. And so that was my first sort of toe into the water in this area. And then I've done a lot of work with other areas of state government. But do you find that we're seeing more people in this state? And do you find that the legislature is well informed on the trend and the funding that's needed?
Thank you, Madam Chair. Thank you, Senator Padilla. That's a great question. It's my responsibility to educate the legislature on this trend, and I will be doing that in October in front of the LFC.
Good.
The general trend is that it is rapidly increasing as we are reducing state budgets, including my agency's budget. So I am doing what I can as agency head to help with that trend. I will say that of the approximately 5,800 guardianships and conservatorships that are active in the state of New Mexico, I did get that number from the courts. We have just under 1,000 of those guardianships. And to be eligible for the Office of Guardianship Services, you do have to be income eligible. I believe it's a 200% poverty level. And we also make exceptions for folks, who really do lack the resources and are very close. So there is an exceptions process in place. And we are seeing as the population ages and, and with the pandemic complications that more and more people are needing guardianship. And when I say pandemic complications, I am including the fact that that people cannot visit folks in facilities, that the state ombudsman, to the best of my knowledge, still are not entering the facilities. If they have, then they've begun very, very recently. So for months, there was nobody in these facilities watching out for them. And so that's what I'm really talking about when I say pandemic complications. And so we have seen, medical issues get out of hand. We have seen instances of neglect. Of course, those are being reported. APS is working on them, and the ombudsman to some extent is working on them, and our guardians who are able to force their way into facilities at times, they're seeing them, or they might be able to tangentially see them. But the folks who really are the most susceptible, I want to say, to neglect aren't ones that the guardians can access right now. And so we're seeing more and more of that trend happening this year, right now, in the past few months. And that's just the pandemic. But again, with the aging population, we were already seeing that in the last, since I've been here. So I started in August of 2019, so just over a year ago at the Office of Guardianship. In that year, there was already a great increase. And then since I've been there, the increase looks almost exponential. And so I've had to, because of funding issues, I've had to stop processing cases other than emergency cases starting in January of 2020. And our wait list is rapidly growing. Just for, because this is related to your question, Senator Padilla, about the funding issues. We did have to go in to the State Board of Finance in FY20 to ask for an emergency fund to get us through the rest of the year. We did get a slight increase in January. Of course, that increase has pretty much been eliminated, due to funding cuts for FY21. And then we, of course, were directed to submit another 5% on top of that. And so we are looking at a pretty significant shortfall for FY21. On top of that, in the past, we had the Office of Guardianship has a fund balance. In the past, there was non-reverting language, and we were able to, so this is a controversial part. This years before I got there, the fund balance grew and grew because every year the Office of Guardianship would come in. I don't believe their accounting was entirely accurate. They would come in and ask for emergency supplementals. They would receive them, and then they would revert a lot of these funds at the end of the year. And so at some point, the Office of Guardianship lost credibility. The EDPC lost credibility with the legislature on, I guess, funding projections and shortfall projections, because there was at one point, I think, $3 million, dollars in the fund balance. $1 million of that was given to the Administrative Office of the Courts to do guardianship work, and they've been spending it, creating training materials and other helpful things. And then I have spent down the rest of the fund balance trying to push out services as much as possible. And the legislature did actually restrict that fund balance on the spending. They said, you can only use the fund balance to reduce your wait list. At one point last year, in FY20, our wait list was 0. And of course, since then, it's been growing, and it will continue to grow until my budget grows. Because once a person gets a guardian, there's 2 kinds of guardians you can get: a family guardian or a professional guardian. For family guardian cases, we pay for the legal services to get the guardianship put into place, and then we don't pay for anything else. For folks who really don't have any kinds of family members or close friends and individuals who can do that role, and it's a really involved role if you're doing it right, they will need professional guardianships, and about 2/3 of our requests for guardianship are for professional guardians. Once we start paying a professional guardian, we pay them indefinitely until that guardianship is terminated. And there's many reasons that guardianship can be terminated, but in order to terminate guardianship, it's another involved court hearing. It's another involved court proceeding that requires, attorneys. Generally, also involves court visitors and guardians ad litem. The only time it doesn't involve those people is if a person passes. And so you are indefinitely paying for a service for a person once they're in guardianship. So that's why, I would love to have a budget that grows, every year. But that's not a reality. That's not going to happen. And that's why it's so important to look at alternatives like supported decision-making, so that we can give people the right level of services and make sure we free up resources for people who need that really high level of guardianship services. I hope that answers your question, Senator. Thank you, Madam Chair.
Madam Chair, and Alice, it was incredibly comprehensive. Thank you. I just really want to make sure that the data and the information is going to be so critical, not just on this program, but across state government as we get, tighter and tighter on our budget. But want to make sure there's a door that's open to you that is showing, what the work is and how much it costs and what it really is. I mean, eventually we may all have to deal with this type of a situation, whether for ourselves or for someone else, that we love or that we care for. So I really appreciate it. I would also offer my help along the way. So if you ever need me for anything, I hope you'll reach out. Thank you, Madam Chair.
Thank you, Senator. Is there anyone else?
Madam Chairman, this is Senator Rodriguez. I just want to follow up a bit, not long, I promise, if I may. Thank you. I just was thinking that in a 30-day session, Alice, I have seen many times actually a piece of legislation coming in with a certain face, and at the end of the 30-day session, it doesn't look like what we saw when it first went in. And so that happens because of the pace that we deal with during the 30-day session, because it's really for a budget. more than anything, and the calls of the governor and so on. But I just wanted to mention that, if we decide to go with the memorial and do the study, then, to be prepared for possible amendments coming up and so on, even after the study. But anyway, so just wanted to thank you once again for all of that. And I'm here to help in any way that I can. And obviously this committee is very, very caring and very sensitive to the issues. So thank you once again to you, Pamela.
Thank you, Senator. Everyone has done such a good job of covering, excuse me, all of these different issues. My question to Ms. Lou McCoy is it sounds like for us to hurry this process would not be a good thing, because we would get something, like you said, would be challenged or would not be respected or have the credibility. But it sounds like and maybe you can tell me more, the work that was done before in the guardianship reform and the task force that did work. I know that the supported decision making, like you mentioned, was contemplated and discussed. Is there enough groundwork from that we could draw on to go forward if we did put, a lot of effort, like to expedite and talk to people and maybe get the national NCSL of state legislators to support us with all of the different states, and we could look at quickly what looked best and then work from there. Best practices from another state, like you were mentioning. Texas is very brief. New York is too strong. What are your thoughts about that?
Thank you, Madam Chair. So my initial thought is anything is possible, but there is a reason why I recommended the path forward today. I think if you're asking about the Supreme Court Steering Committee specifically, I don't believe is enough groundwork laid out there in that arena for support. I don't think that it means there can't be before January. I know at least of one other meeting that they're going to call either in late December or early November. We're meeting again in early October, but that's just to finish up the last meeting. We couldn't get through our agenda. So there is an opportunity to get that group of folks on board. I think it's crucial that we get that group of folks on board. Again, there are legislators who also sit on that committee. I believe Representative Eli is one of them. And so anything is possible. I don't think at this very second we are there yet. That is not to say that we couldn't do all of the things that you just suggested, Madam Chair, and try to get there. So, I'm not opposed to working with legislators on this. I would also like to see the governor's support on this as well, and a legislative proposal be submitted to the executive, because I think having her support would be really crucial as well.
Thank you. I appreciate your honest answer about that. And even if we did try, but found that it wasn't going to be the broad support that we needed, then we could just stop it right there and go with the continuing funding for a task force, I think. So thank you very much for all of this, because I think this is so important as an alternative. And what was meant in like you were speaking about, the ladder of alternatives, the protection arrangements, the limited guardianship, and you're going to be speaking about, why this is so necessary too in the next panel. So thank you, and we will go to the next panel. How's that? Right. Thank you, Pamela, for being with us too.
Thank you.
Okay. So do you want to bring up the next?
Madam Chair, Representative
yes.
Lujan did have a question.
Oh, I'm sorry. I thought her name was up and then she took it down. So Representative Lujan, do you have a question?
Thank you, Madam Chair. And yes, I do. And thank you, Alice. I just know with everything that has been brought up through this discussion, and it's a great discussion and of great importance. And so thank you, Alice, for being with us today and for all your information. But through the conversation, I just wanted to ask a question about right now. What are the safeguards that currently exist to report guardian bad decision making and oversight or overspending for an individual with disabilities finances? And I know that we have, corporate controls or interests that are monitoring or in charge of those finances. And so do we have anything in place for like whistleblowing procedures to, for families or outside parties to, or are they in place so that we can address that now?
If I may, Madam Chair and Representative Lujan, did I say that correctly?
That's correct.
Okay, thank you. I'm sorry. I think I'll answer those questions, if I may, in the next presentation, which
Sure.
is going to be incredibly relevant to what you're saying. I will say that, though, that outside the context of guardianship and conservatorship, right now there is a task force, a financial exploitation task force that is working on proposed legislation for this upcoming session. I'm on that task force, and we're working right now on proposed statutes on both the criminal and civil side for financial exploitation. And this is for folks who are not under guardianship or conservatorship, just people who may be susceptible to that kind of exploitation.
Wonderful, thank you. And I was kind of wondering if I was going to hold over to the next presentation, but thank you. Yeah, if you want to address it further there, I'll see about asking a follow-up question. Thank you so much again. Thank you. Thank you, Madam Chair.
Thank you. And we have an attendee who has a question, but we'd like them to submit a question when we go to public comment at 3:30 this afternoon. And if you can't stay for that or join us again as the attendees, we can go ahead and ask the question, and then you can look at it as a recording. So thank you very much. Okay, since we're running a little bit behind, would you like to go ahead and speak about expanding the oversight of the DDPC over guardianship and conservatorship?
Thank you, Madam Chair. And I hate to ask you this because, again, we are running behind, but I very badly need to run to the restroom. And I believe after my presentation, I will have questions, and I'm not sure how much longer.
Okay, we'll take a short break.
Very short, very, very, very short. Thank you, Madam Chair.
Reminds me when we're on the floor for a 3-hour debate and we can't leave. Okay, thank you. We'll just, let's see, does anyone have any other comments or discussion?
Madam Chair, this is Peter. May I just make a quick comment about per diem?
Yes, sir.
Thank you. Committee members, please note this is not a requirement of council service, but a requirement of DFA. But to receive per diem, please email me, or in this case for this subcommittee, but for every committee, the lead staff member, an email that specifies the name of the committee, the date the committee met, and whether you went per diem. And all that has to be in the email. Also, if it's a hybrid meeting and you do come physically to the meeting and you want mileage, please specify that as well. I'm sorry, I know it's a lot to ask, but it is not a requirement we came up with, and DFA is requiring it to send out your per diem. So thank you very much. I just wanted to clarify. And some of you have already done that, and I appreciate it.
Thank you.
Thank you.
Madam Chair?
Yes.
This is Liz Stefanix. The comments that I made earlier with Director McCoy, I was really talking about a pretty lean bill that could include the task force and that could include developing the standards after the task force met, but a bill that would actually get the category listed in statutes. So I understand what everybody is talking about in terms of the complications, but we have had some bills like that in the past. And so I just wanted to reiterate that. Thank you so much.
Oh, that's an interesting concept. We'll have to discuss more about that. Okay, it looks like our presenter is back, and I was going to introduce Representative Dow. She was here briefly, and I don't see her again unless she had to go to just to telephone. And if everyone could lower their hand, that they raise their hand that I was missing. Okay, anytime you're ready.
Thank you, Madam Chair. So I'll try to be fairly quick with my my presentation so we have time for questions. One major issue that has come up today already and then over again that I see, and I've had conversations with multiple legislators about this, is the issue of guardianship oversight and monitoring in New Mexico. And so I want to start with an overview of what the Office of Guardianship does. So there's, there are, memes out there that, show, what these people think we do, what other people think we do and what we really do. And I think one thing that we can all agree on is, I think a lot of people think the Office of Guardianship already does guardianship monitoring oversight of all guardians in New Mexico. We actually have a very limited authority about what we can do. And specifically, what Office of Guardianship does is provide legal services and guardianship services to income eligible people who may be eligible for guardianship. And so if we determine that a person is appropriate for guardianship from our own perspective and our own expertise, then we will provide legal services. We'll provide an attorney, a court visitor, a guardian ad litem, and we will petition for guardianship from the courts. Of course, the courts are the ultimate arbiters of whether or not a person needs a guardian. And once that the court has made an order for guardianship, then we provide, if the court has made an order for professional guardianship, then we provide the professional guardianship services and we pay for those services, again, until the guardianship is terminated or there's a determination that the professional guardian is no longer needed. So we have also done transfers of guardians from professional guardians to, for example, a close friend or family. We've done that as well. So those kinds of guardianship transfers. So the three priorities when I walked in last year that we laid out was the number one thing is we're always focused on the person. Everything that we do has a person-centered approach. We care about the protected person. We care about what legally is called the allegedly incapacitated person. Everything that we do is centered around what that person needs and tailored to what that person needs. And that's why we're moving toward a more limited guardianship model where we are really doing on the front end what we need to do to figure out where is this person at and what level of support do they need as far as guardianship. And so the first thing we want to do, right, is ensure that the existing services we provide are top quality. We have developed an expertise in guardianship standards, best practices, legal and statutory requirements. And so we want to make sure that those are being followed. And then, of course, we do very strict contractor compliance, which I'll talk about later. Another thing I wanted to do, we discussed for the last couple of hours, is developing this comprehensive ladder of decision-making support services. The Office of Guardianship, I think, is leading the charge in bringing guardianship or the world of guardianship to modern times. I think, our statute was recently revised, but the bones of that statute, hadn't changed in many, in decades. I want to say maybe the 70s. And so there had been some tinkering, but the overall structure of the Uniform Probate Code statute that we put into place decades ago has gone through many iterations since. And today, the Uniform Probate Code looks very, very different from our statute. So even though we may call ourselves a Uniform Probate Code state, it looks nothing like the current Uniform Probate Code. And that's the statute that controls probate code guardianships. That's what I call them. So there's two kinds of guardianships: probate code guardianships and treatment guardianships. And treatment guardianships are within the purview of mental health courts and are solely guardians who are appointed to make treatment decisions on behalf of people who have mental health challenges. And so that's, we do both kinds of services at our office of guardianship. And then finally, we have our third major priority is expanding the oversight and monitoring of guardians. And that's what I want to talk about today. So I think this slide doesn't need a lot of attention. Everyone here knows what a guardian is. But for folks who don't know, a guardian is a substitute decision maker. Guardian is appointed by the court to make decisions on behalf of the individual. The guardian should consult the individual, but the guardian has the final say in all of the decisions that the court has ordered. They have authority over. A conservator, as I mentioned before, is appointed by the court to manage finances of individuals with substantial assets. And so folks who are on Social Security and may not have Social Security income, not to say SSD or anything like that, but folks who don't have substantial assets would not have a conservator. And so in those situations, the guardian does control finances. There are other kinds of financial controllers. For example, the representative payee who is appointed by the Social Security Administration to manage a person's Social Security income. In some cases, the professional guardian is also the rep payee for the person. In other cases, the rep payee is a separate individual or a separate agency that does that. So everyone wants to know who guards the guardian, and this should answer Representative Lujan's previous question. So ultimately, the New Mexico courts have the ultimate authority to look at guardian issues and to decide if a guardian is appropriate or doing appropriate actions, or if guardian needs to be changed, because they have what is called continuing jurisdiction over the case. So once a guardianship case is brought to the courts and a guardianship is put into place, that court has continuing jurisdiction, meaning that that judge or the person sitting in that judge's position, the next judge, I guess, their successor, that court will have continuing jurisdiction. And if you want to move, for example, jurisdictions, if you're a person who's moved to another judicial district and you would like your guardianship to move with you, that's a whole court process where you have to transfer. This becomes an issue across state lines as well. It also becomes an issue when the guardian lives in a completely different state from the protected person. Excuse me. So again, the courts are the ultimate guardians, right, of guards of the guardians. As I mentioned before, they are statutorily required to do a 10-year review. So at a minimum, they must do the 10-year review. Other ways to access the courts are to ask for requests, to have requests for hearing. Attorneys know how to do that. That's no big deal for them. But for folks who are not themselves attorneys or who don't have attorneys, anybody can access the courts to discuss the guardianship or to bring issues to the court's attention for guardianship. One of the statutory changes that was recently made in SB 19, as was discussed before, is the creation of these grievance forms. They're online on the court's website, New Mexico court's websites. And anybody who wants a link, they're easy to find actually, but if you want a link, feel free to email me, I'll forward you the link. And the grievance forms can be filled out by anybody about a guardianship situation. And these grievance forms go directly to the court, and the courts are required to address the grievance forms as they come in. And so another way to access the courts are letters to the court. And so this is one situation where you don't necessarily have to file a motion or have an attorney. If you see an issue with a guardianship happening, everybody is free to write a letter to the court. They prefer you to use this grievance form. And I think the grievance form is probably the best way to go about it because there is an official process in place and there is a requirement that the court look at this form. So I highly encourage folks to use this avenue of oversight in reporting. And so we all know that the courts have very limited resources, that they aren't really able to do required reviews more than once every 10 years. And, and it really depends on the court's dockets, when you're going to be heard. And, there is some kind of determination how important the issue is. All sorts of things can happen that make it a little harder to access the courts. And plus being in court, of course, is very intimidating as well. And so a lot of people avoid that. And then there, of course, the courts really only have control over what's happening in their courtroom. So whatever information comes to the court, needs to be basically given to the court. So, for grievance forms, it's whatever information is given in the grievance form. For hearings, it's whoever shows up and whatever documents get filed. That's all the court really has to work with as far as, what the court can do for you. So, who's on the ground looking at what's happening? Who is there, at the home, or who is there talking to people outside of the courtroom? Well, there are a couple of state agencies who do this kind of work for financial oversight. A few years ago, I want to say 2018, but it could be before, I think it was 2018, the Office of the State Auditor partnered with the courts on a pilot project to do financial oversight of guardianships and conservatorships here in New Mexico. The report of that pilot project was finalized earlier this year, and State Auditor Cologne and Supreme Court Justice Shannon Bacon did a press conference, rolling out this report and announcing that there will be ongoing financial audits done by the State Auditor's Office on behalf of the courts. In the pilot project, it was set up so that the auditor could do random checks of specific cases, and the courts could also come to them with cases that they had financial questions about. And the state auditor's responsibility in this pilot project was to, take a good look, and I think they also had to look at cases under the Office of Guardianship as well. And so I did do a final interview earlier or last year, I think late last year, with the auditor's office as they were rolling up their reviews. And of course, the cases they were reviewing, were before my time, but it was really good to know, where they stood. And one thing I did notice is that the state auditor's office is incredible in their audit expertise and their financial expertise, but they didn't know a whole lot about guardianship and how guardianship works. So I think they're developing that expertise. I have confidence that they're going to do a good job with these financial audits. The courts really are happy to rely on them as financial experts and resources in that respect. So I think there is a way to ask for a financial audit of an existing guardianship through the grievance form. You can ask for anything through the grievance form. And so I'm not sure how they make the decisions now about who gets audits, but I do know that the goal of the courts and their hope is to one day do an audit of every single case in New Mexico, a financial audit. So that's what we have so far for financial oversight. As you know, there is a whole broad range of decisions that guardians make, and there isn't anybody in place right now to make the rest of that. Now, we also do but we do oversight as well of guardians, but only guardians that have state contracts. So if you're a guardian who is a contractor for the state of New Mexico, then you are one of my contractors under the Office of Guardianship. And we now have really extensive contractor compliance processes in place that I'll go through in a minute. But that's one avenue of oversight as well that exists. But again, of the almost 6,000 cases, that's fewer than 1,000. So just a fraction of the cases that are out there have that level of oversight. So I'd like to talk a little bit about some of the processes we've developed. In 2017, the Office of the State Auditor did publish a report stating that the Office of Guardianship did not provide substantial or adequate oversight of their contractors. And since then, and especially in the last year, we have worked very hard to develop processes where we're looking very closely and ensuring that the quality of services being provided by our contractors to our protected persons, to the people that to the cases that the state of New Mexico is funding, that those cases have high quality services. And so one of the things that we do are called comprehensive service reviews. They look at documents. We speak to the contractors themselves about the cases. We make sure that all of our contract provisions are being followed and complied with. We make sure that standards, professional standards, ethical standards, legal and statutory requirements are being followed. We ensure that the quality of services is where it needs to be. That's one of the reasons why it's very difficult to for us as a state of New Mexico to give adequate oversight to some of the problems that are happening in guardianship, because in order to be a contractor with the state of New Mexico, now you have to have a high level of services, high level of quality in order to be one of our contractors. And so because we don't contract with folks who don't meet that standard, we don't have oversight over those folks either. And so they are the only oversight available for for guardians who are not contractors of the state of New Mexico are, of course, the courts and their limited resources. So another thing that we do, which is incredibly important and what we've expanded quite a bit this last year, are protected person welfare visits. We talk to the protected person themselves, check in on them, see how they're doing, and see if the level of services that they are receiving are adequate to their needs. Do they need a higher level of attention from their guardians? Are the guardians needing additional authority to help them with additional issues that the initial guardianship order may not have contemplated, because maybe they have a deteriorating medical condition and it's made their capacity even less than it was when the guardianship was put into place. Do we need to expand that? On the opposite end, do folks need to have less restrictions on their rights and their decision making? Are folks eligible to graduate out of guardianship? There are individuals and protected people who no longer need guardians, who have capacity and want the freedom to do what they want to do. We have guardians also come to us and say, look, I haven't really done anything for this person. They haven't needed me. They've lived great lives. They have jobs. They are making their own decisions. I'm just signing off on them because I agree, they're making great decisions. They don't need me. And so those kinds of situations do happen. And unless we're out there paying attention to the cases that we have, excuse me, we're not going to see that happen. And we would have to depend on the guardian to come to us and tell us, hey, this is a really easy case I have here. I don't have to do anything for this person. We do have to depend on our contractors to tell us, but we're not doing that. We are going out there and paying attention to what cases, what the needs of the cases are. And so one thing I will say is we are rapidly going to run right by the 1,000 mark. We have cases that are already in the pipeline before I stopped accepting or processing any more cases. We still have cases that are being put into place, and so we will be over 1,000 before the end of this fiscal year. Another thing that we do, we have a complaint process. So if there is and we'll take a complaint from anybody. If there is an issue with a guardian, there is a process in place. We are trying to make that process better and more user-friendly. I think it could be much better. We're working on changing regulations, doing some regulation revisions. And of course, those will be out for public comment when we get around to that part of the process. But we do have a complaint process in place, and we're doing our best, under the current regulations to make it as user-friendly as possible. And anybody can make a complaint about our guardians to us, and we will, it has laid out in really specific detail what we'll do once that complaint is filed. The complaint process is another issue that has come up in the Office of Guardianship. And so in the last year, we have tried, we've done our best to make the complaint process not only as user-friendly as possible, but as comprehensive and useful. And then we're also working on giving it to a third-party vendor to look at so that it is truly a neutral perspective. Looking at these complaints. And so while we like to keep everything in-house as much as possible, especially in these strict financial times, there are some things that do need that neutral third-party perspective. And this question has come up before, and I'm just going to answer it now before it comes up again. Who do you complain to about the Office of Guardianship? Ourselves, right? And we do, and there is a process in place where you go to the Human Services Department, and I'm happy to also give information to people about that as well, if that's an avenue that people feel like they need to take. So there is a really comprehensive complaint process in place as well. And we also do ongoing trainings and roundtable discussions with our contractors, where we bring emerging issues and issues that contractors are seeing. The most recent ones, of course, are dealing with pandemic issues and visitation issues. And so we will be doing, and we've just done our big annual trainings for our for our legal professionals as well as our guardian professionals. And that just happened, I believe, in August. So again, when we're talking about contractors, we're talking about not only the guardians themselves, but we're talking about petitioning attorneys, guardians ad litem, who are also attorneys, and court visitors who usually have expertise in social work. And these professionals are so important as well in the process because they are sort of the gatekeepers of guardianship cases. Well-trained, legal professionals will ensure that the right people get brought to the court's attention for guardianship, and that the right level of guardianship is provided for the person. So it's essential that we do really good trainings for legal professionals. We also provide one-on-one assistance all the time on cases. Our contractors do call us to consult with us on decisions that they're making for their protected people. If it's a difficult case, if it's a case that has a lot of complicated issues, we're happy to work with them and provide that kind of assistance. And then as far as our legal professionals, we do have in-house attorneys. We have a staff attorney, Mary McCauley. She does a lot of legal support, and she also appears on behalf of Office of Guardianship in court proceedings. And so we provide legal support as well as training for legal professionals. All of this is to say that we are the only state agency that has developed extensive expertise in guardianship standards, and that includes best practices, legal and statutory requirements, and ethical. So one avenue that we're considering and that we'd like this subcommittee to consider is a proposed pilot project. And if you remember, the Office of the State Auditor began as well as a pilot project. The goal, of course, is to have comprehensive guardian monitoring across the state of New Mexico. That would be the goal. But we're also looking at realities of our resources. We're also looking at realities of, how would this program look? I will say that based on my knowledge, the pilot project with the state auditor's office did reveal the many different ways that that kind of partnership could fail if issues weren't addressed in the right way. And so one thing a partnership or a pilot project does do is it helps test how that partnership would work. In order for us to do oversight and monitoring, we have to have a partnership with the courts because, again, they have the ultimate authority over all guardianships here in New Mexico. And so that partnership needs to be very carefully and thoughtfully crafted. And of course, we're already in discussions with the courts on what that would look like. And really our only, the next step, of course, would be some kind of legislation to give authority to the Office of Guardianship to do that work. As I mentioned before, New Mexico has over 5,800 guardianship and survivorship cases, and we only oversee about 1,000 of those cases. And even though the Office of the State Auditor conducts financial audits, there's no state agency that oversees or monitors, the quality of services provided by guardians that include other decisions like healthcare, residential, visitation. There are many life decisions that that may not necessarily fall under the audits, the financial audits. Of course, whatever work that we did, we would have to get the buy-in of the Office of the State Auditor too. We don't want to duplicate services, and we want to be able to refer to each other freely depending on what expertise is needed in a particular case. And so, in a perfect system, the courts would have both the state auditor's office and the Office of Guardianship working together to look at cases that may require one or both of our expertise to make sure we would be the eyes and ears on the ground to make sure that people are being adequately protected. And as I mentioned before, we are already working with the courts to design a proposed pilot project. But again, this is just one avenue that we're exploring, and we're open to others as well. So the proposed pilot project, if it moves forward, will target 2 judicial districts, one more densely populated and one in a more rural area, because as we know, the issues are very different in different areas. And we want to make sure that when we're crafting a oversight and monitoring process, we're doing it in a way that is going to be responsive to every part of New Mexico. And one way that we can adapt and learn is, of course, the state auditor's office has already done a pilot project, and they already have a partnership in place. So we can look at the structure of that partnership and see what has worked and what hasn't worked, and what what they learned from the pilot project. So we don't have to reinvent the wheel. Another existing model that we can look at in the 2nd Judicial District, there are a couple of staff attorneys that the 2nd Judicial District has used to do this kind of a similar kind of oversight monitoring just for this particular judicial district. It doesn't exist in any other judicial district. And what we would like to see is the same level of support and services or support and oversight of guardianship that happens at the 2nd Judicial District. We'd like to see that happening all over the state of New Mexico. And the Office of Guardianship is in a good place and position to provide that service for all other areas of New Mexico outside of this metro area, or specifically, the 2nd Judicial District. So in order for us to do that, we do need legislative action. The DPC's authority right now is, of course, only over its our own contractors, our own guardianship contractors and professional contractors. Legal professional contractors. And so we would need some kind of legislation that gives us the authority to do additional oversight and monitoring and to work with the courts on this kind of work. And now I'm available for questions if anybody has any. Thank you, Madam Chair, and thank you, Subcommittee, for allowing me to present this topic.
Thank you so much. I'm checking to see if there are any questions. Yes, Senator Ortiz-Pino.
Thank you very much, Madam Chairman, and thank you, Alice. I have to say that the issue of oversight over the guardianship program was one that we spent a lot of time debating during that task force that I was part of that tried to reform the guardianship program. And whenever we got close to suggesting that the DDPC be the body, it did not have a great track record in those days. And so people would veer away from it, even though in a lot of ways it is the most appropriate place. The issue really is that there's nobody else in state government that wants it, or that wouldn't have a conflict of interest in handling it. Adult Protective Services and the Aging and Long-Term Services Department, they rely on the guardianship program as a resource. The Administrative Office of the Courts, I think they might view it as a conflict of interest. I think it really makes sense, but it would have to be beefed up, and I think that's what you're suggesting with the pilot. Until you took over, I would have been very hesitant to say, gee, that's really where we need to go. Do any other states, to your knowledge, Madam Chairman and Alice, do any other states use their Developmental Disability Planning Council as the monitoring and oversight body for guardianships?
That's a good question, Madam Chair, Senator Ortiz-Pino. To my knowledge, I don't believe there is another state that uses their DD Council specifically as the oversight and monitoring entity. However, I do know that a lot of states that have oversight and monitoring systems or groups, they either sit within the courts themselves, so something like what the judicial district kind of has, right? Or they are even a volunteer program that is run. And I'm open to all suggestions, but even the volunteer programs themselves, I believe, are either run by the courts or are in partnership with the courts. So whatever happens, the courts have to be involved. I don't know, that doesn't mean it doesn't exist, Senator, but I don't know of any DD councils that do this kind of oversight mode. But but also this wouldn't be funded by federal funds, our DD federal funds either. It would have to be a system that's funded by the state.
And Madam Chairman and Alice, the point you made about there are two kinds of guardians, family or professional. There really are three, because you've got the ones that we may call professional, but that a judge just names somebody that he's either has confidence in or has twisted the arm of or is old friends with to take it over. Usually another attorney or something, rather than an agency that's designed specifically to do that. And that's the group that we have little or no oversight over right now. So I think we clearly need an authority within state government to tackle this. And I'm willing to consider using the opportunity for a pilot project as a way to see if it can work. I just had a couple of other questions. The issue, Madam Chairman, that Senator Papin brought up, and I can't remember I think it was when we had in Health and Human Services the presentation by Aging and Long-Term Services Department. Senator Papin brought up one of these cases in Doña Ana County where the judge had named an attorney to be the guardian, and the family was complaining to the senator that this guardian wasn't doing any of the things that we're supposed to, was basically blocking the family from having access. It was like we had never reformed the system at all. And it hit me as I heard her talking about that we rely so totally on the judges who name the guardians to monitor the guardians and to adjust any oversight that it's just we've created a system without any checks and balances if we do it that way. So we do need somebody to check on the courts as well as on the guardians. And that would take legislative action. And as Alice suggests, Madam Chairman, we really ought to have some legislation that would do that. I just wanted, Madam Chairman, to also get Alice's idea or response to an idea that I've been pushing. 5,800 cases statewide is a lot. And to monitor all of those every year would take a considerable investment of state money. And yet that's what we really ought to be doing, is having those guardians file a report every year and then verifying it. On the other hand, we have the model of the IRS, which uses a sampling. And going in, that you may be one of the ones picked this year to be checked. You may not, chances are you won't, but if you are, you're going to be thoroughly monitored. And just knowing that tends to keep all of us honest in our dealings with the IRS. And I wondered how you would react to that, to the notion of a sampling approach to these annual reports that the guardians have to file with the courts, rather than an 100% review. Would we achieve essentially the same accountability from the monitors, from the guardians, without having to necessarily look at every single report every single year?
Thank you, Madam Chair and Senator Ortiz-Pino. I'm also, okay, am I echoing now? Okay, oh, sorry. I'm going to address the last question last because I think it's easier. We already do that sampling approach for our own guardianships. I don't have enough staff to review all 1,000 cases every year. So we do the sampling approach, and we do a sampling approach on the contractors as well. So the contractors know that they may not have their comprehensive service reviews done on them every year, but they could be, done that year. And we have, I don't have an exact number, but we have about 20 different guardian contractors anyway. And I think we do a sampling. Sorry, I'm going to misspeak because we've expanded this quite a bit. I know, so last year I think we did 5 or 6, and then we are, and any of my staff is free, if you're watching, to text me any corrections on my numbers. And we're really expanding the number of cases that we're as we get better and better at what we're doing. So yes, the sampling approach is great. I do want to make a couple of comments, Senator, on some of the things that you said. We do have, as part of SB 19, there is a requirement. So as far as the third group that you're talking about, there is a legal definition for a professional guardian. And a professional guardian isn't necessarily a person who's a corporate guardian or has a company. Professional guardian only needs to be a guardian of more than 2 people. And so if you're a person who is guardian for more than 2 people, whether or not you're being paid, you're a professional guardian. And there is a requirement under state law now, because of SB 19, that if you're a professional guardian, you must be certified by the National Guardianship Association, by their Center for Guardianship Certification. And you must show your certification to the court, provide proof to the court. And one of my staff just said, okay, so 10 is scheduled. 20. Okay, 10 is scheduled for this year. So, okay. Just so everyone knows, we're really expanding that that review process. So you do need to show your certification, and every single person needs to be certified. So folks who weren't certified before, by now, there was a rollout period, or a grace period, that was built into the statute for folks to comply with that certification. But now everybody, if you fall into the category or the definition of professional guardian, then you must be certified. Now, again, this speaks to another issue that you brought up, Senator, about relying on the judges and courts to really understand what we're doing in the law. So I think many judges and some judges still don't really understand the new revisions that we've made in the law. And I know the courts are working very hard on doing judicial education on that front, because every judge in the state has guardianship cases. There's just so many of them. And one issue that I did see in a particular case, I'm not free to share any details, but I can say that this particular judge didn't, and the attorneys that were involved didn't know about the certification requirements, and it never came up. And so, you know, it took an outside person to bring this to the courts and attorneys' attention. Hey, you guys practicing this law, there's a new requirement, and this guardian that you're proposing must meet it. And so, you know, I know the courts are working very hard on judicial education. So we would like to partner with the courts to do that. I had one judge tell me that the best education they got about guardianship came from attorneys who knew the law very well and was able to show through their practice and through representing their clients in the best way possible, you know, what a good guardianship looks like. And so I think that being a resource, office guardianship being a resource to the bar, right, the guardianship bar, to attorneys who practice in this field could be a really big benefit as well. And we are doing that. You know, we're trying very hard to, and we continually do presentations with the New Mexico Guardianship Association. You know, we try to do that kind of professional outreach. And of course, we train our own contractors. I hope that answers some of your questions or addresses some of your concerns. Thank you, Madam Chair.
And Madam Chair and Alice, just one final comment. This is a really serious issue in our state, and if we're gonna have guardians, we need to adequately fund the system that monitors them. And so my heart sank when I heard Alice say that her office was also being subjected to the request to reduce their budgets for this coming year. That's going in the wrong direction. And I think if we're serious about guardianship, we need to adequately fund it. And I just wanted to leave that with that comment, Madam Chairman. Thank you. Thank you, Alice.
Thank you, Senator. That was great. And we have next Representative Tara Lujan.
Thank you, Madam Chair. Thank you again. And Alice, it's a wonderful information, a great presentation. Thank you. I just wanted to add a couple of things and ask a couple of questions. I'm curious, and I'm glad that you're working with the pilot program with the State Auditor's Office. But I want to bring to your attention, if you don't already know, which you may, about our ABLE Act, our New Mexico ABLE Act, Achieving a Better Life Experience Act, and that's being run through the State Treasurer's Office. So have you worked with them on building? Okay, building, great, thank you, because that's just another tool that we have in our toolbox that we can use. And I like it. I know about it. I don't know everything about it, but it does create some transparency in the oversight aspect, in the spending and the finances, because when you create an account under the ABLE Act, you're able to document your receipts, upload them, and it corresponds with the other spending that's going on. So I just wanted to talk about that or comment on that. The other thing I wanted to ask is, with the oversight that exists with the corporate guardians that have the pool of trust, and sometimes and they have the ABLE Act, or people with disabilities want to add on the ABLE Act as a finance resource for themselves. I'm aware that some of our corporate guardians, like the ARC, have not allowed access to our individuals with disabilities to access their money into the ABLE accounts, and these cases are going to the Attorney General's office. So how can we have this issue studied in a House memorial that you're talking about, or is it something that you're already going to add into the memorial? I haven't had a chance to review the past memorial, excuse me, that you had. So is that something that you would be studying or something that you could add to it? Thank you. Thank you, Madam Chair. Thank you, Alice.
Thank you, Madam Chair, Representative Lujan. So I see that Pamela is still on maybe, and if she's willing, I'd like to see if she has any comments about the Arc of New Mexico. But before I get to Pamela, I do want to say that if we're talking about the task force for supported decision making, yes, we should explore all avenues. For supported decision making, of course, it would be up to the person themselves whether or not they want to use ABLE accounts, and if they want to do that, then their supporters should do what they can to help them work through that. We have at DDPC worked closely with the state treasurer's office. Because our focus is on developmental disabilities, these ABLE accounts are a huge resource that we've done trainings about, that we've tried to learn more about. And then I, of course, am also working personally with Denise Balderas over at the Treasurer's Office on ways that, not only the ways we can bring ABLE to our populations here in New Mexico who may be able to utilize them, but really we're working on a broad range of disabilities issues or issues that folks living with what Denise likes to call exceptionalities, issues that they are dealing with. They could be education and otherwise. So there are a lot of different areas, right, when we're talking about working with folks living with disabilities. And I am open to, and I believe we should take all of these different areas into account when we're doing our work on the task force. I hope that answers your question, Representative. Thank you, Madam Chair.
Thank you, Madam Chair. Thank you, Alice. Yes, and I'm just bringing that, I mean, the more tools that we have that can help us with accountability and transparency, because through the process that you discussed with us with going through the court system, we know that that takes a lot of time and a lot of resources. So I support what Senator Ortiz-Pino was talking about in the funding for your work and what's going on, because we need the oversight and working and talking about our most vulnerable populations. I mean, we need to take into account how the budget cuts and everything are affecting our most vulnerable. And so I just wanted to say that this is really important work that needs to be done and needs to be funded. So thank you again for all your work that you're doing. It means a lot to all of us, but especially our vulnerable populations, we need to really protect right now. And you bringing up COVID, especially, COVID has brought to light just so many inadequacies and so many things that need to be done. So we're going to learn a lot from that, and I think that that's going to be something you're going to maybe add or talk about in the memorial, I hope. But I'm happy to talk more about this with you outside of this conversation today. So thank you again, Madam Chair. Thank you, Alice. Thank you.
Madam Chairman, may I?
Yes, please.
So the ARC New Mexico has been a huge proponent of the ABLE Act, both in passing the legislation and also actually had a small contract with DDPC a couple of years ago to assist the Treasurer's Office in doing outreach to Native American populations and making sure that the tribal communities understood about the wonderful work that the ABLE Act allows. Individual guardians have to make individual decisions based on the individuals that they're supporting. And so I do know that there has been many individuals that we are guardians for where we have absolutely opened ABLE accounts. There's other situations where, for a variety of different reasons, we may not want undue influencers to have access to some funding. Those are individual decisions, and I'm sure our director of guardianship would be happy to talk with anybody about those concerns.
Madam Chair, Pamela, thank you for that information. I do appreciate that. And there are just some other, that's just what's been brought to my attention of what's going on there. And yes, I'd be happy or open to having this further discussion. Thank you.
Thank you, Representative. Are there any other questions from the committee? I don't see any, but didn't know if Representative Miguel Garcia, if you're still on, if you had any. Okay, looks like, well, I would just like to add the case that Senator Papin and Senator Ortiz-Aquino were talking about has been one that has motivated, even though I've been working past couple years, even with other cases where family and friends couldn't visit or see or take care of a veteran that was secluded by the guardianship program. And she, when she passed away, that was the only time that that guardianship was severed, and that the family and friends could then, do something for her. So, and there's also the, retaliation that happens sometimes with the guardianship program that families and friends have found if they speak up too much, then there's a price to pay. So, and I think that it's going to be important to give this other, to have this pilot program so that we can see how we can support the courts in a better way, and definitely is going to take more funding, like Senator Ortiz-Aquino was saying. We just can't cut back on things like this. In Las Cruces, we have so many retirees coming here, and if they are in a situation where they don't have family or friends close by and they need someone to help in the courts, we need those extra steps, such as the supported decision making, also to happen in our state. So it's I know there were a lot of people who are very much impacted by how the guardianship program goes, and we need to do everything we can to make sure that things that like happen in Nevada, where you have so big a population and so many people who are vulnerable to predators in guardianship cases, that doesn't come to New Mexico, and that we make sure that we take care of this before something like that should happen. And I think it has happened in Albuquerque. There was a case where people were, they fled, but someone was held accountable, and we need to be sure that that doesn't start happening again in our state. So thank you so much, Director McCoy, Lou McCoy, for all that you've done already in your brief time of being here, and in your position. And I know with two young children, and you're just like Ginger Rogers dancing backward, and we know that we want to support you, and you're carrying through with this and making sure that we can do this right, and not to preempt what should happen, but do it as quickly as we can. So thank you again. Are there any other questions or comments? Okay. We're done a little bit early. I guess we could have carried on the first. We're about a half an hour early before we were supposed to break. Is there anything from staff that you would like to mention that needs to happen?
Madam Chair, there is another presentation from the DOH that was scheduled to start at 11:15.
Oh.
And they should be ready to go.
I'm sorry, I skipped down right past that. So we're not early, we're behind. So let's go ahead with that presentation. This is on the update of developmental disabilities and the VIA waiver program. And we have Jason Cornwell, acting Deputy Secretary from Department of Health, and Scott Doan from is Deputy Director of Developmental Disability Supports Division of DOH. I apologize.
No apology necessary, Madam Chair. We could forego our presentation and all go to lunch and just go to the next group if that's acceptable to you in the committee, ma'am.
No, we look forward to you presenting. Thank you.
Okay, thank you. It's an honor to be presenting to you in the committee today. I was fortunate enough to be able to present an update last year. And so I'd like to introduce the acting director of the Developmental Disability Supports Division, Mr. Scott Doan. So Scott will be taking us through the presentation today, and then he and I will stand for questions when the presentation is over. So Scott, over to you.
Thank you. Good morning, Madam Chair, members of the committee. Thank you, Deputy Secretary Cornwell. I appreciate the opportunity to present to you all today on updates on our home and community-based services, specifically the MeVia waiver, the medically fragile waiver, DD waiver, and our brand new supports waiver. And so I do realize we're running late, so I will try to be brief in the presentation, but not rush, to allow time at the end for questions and discussion. And so before I get started, I just also would like to take this opportunity briefly to recognize our Cabinet Secretary, Kathy Kunkel, in all of her leadership and support and throughout her years in her varying roles with state government. As most everyone knows, Secretary Kunkel has announced her retirement. She's still very active in the leadership, and we do appreciate Secretary Kunkel, and she will be greatly missed by the department and many others as well. So I just wanted to make sure and send our thank you and appreciation to our Cabinet Secretary, Secretary Kunkel. Briefly, my face is probably new to many members of this committee. My name is Scott Doan. I'm one of 3 deputy directors with the Developmental Disability Supports Division. I have worked with DDSD for 20 years. And prior to that time, I started my career as a direct care staff, working with individuals with developmental disabilities, and also spent time as a case manager. So I just wanted to offer a very brief background of who I am and what my experience is. And I live and am based in Las Cruces. So I do work out of the Las Cruces office. Currently, office is working from home. And so thank you for allowing me to take that moment to thank our secretary and to a little bit about myself. So next slide, Deputy Secretary Cornwell, thank you. So the mission of DDSD is to effectively administer a system of person-centered community supports that promotes positive outcomes for all of our stakeholders, with the focus on assisting individuals with developmental disabilities and their families to contribute to their community. So our real goal here is we want to treat individuals with developmental disabilities as anyone else in the community, to include their families, and it's our job and our mission to support individuals with disabilities to be active and engaged and productive members in the community. Not just people who are seen in the community, but who are actively engaged and contributing members to the community. Next. Our vision is for people with intellectual and developmental disabilities to live the lives they prefer in their communities. I think the key here is lives they prefer, not necessarily what we want for them, or not necessarily maybe what friends or families want for them, which are important, but we want to make sure that all of our work is focused on the individual and their desires, their dreams, their aspirations. And to that extent, that's our vision and families, friends, guardians, support networks are essential and key to that vision as we support people to help them live their lives as independent or interdependent as possible in the community. Some of our principles is, we want to stay results focused. We want to have a system that is simple and accountable and transparent. We do work really hard to have a simple system. However, we do work with Medicaid and the federal government. So sometimes our systems aren't as simple as we would like, but we certainly make our best effort to simplify the system. Under the direction of Deputy Secretary Cornwell, we have worked really hard to be transparent in our decisions and our communications with the field, even if that means that we're delivering a message that is not popular. It's important to be honest, speak with integrity and respect as we communicate and are transparent to the field. We do work in partnership with various stakeholders. We'll have some slides on that here in a little bit. We want to promote choice and emphasize prevention, keeping people healthy and safe. So how do we meet those principles? So our actions are accountability. We want to make sure to demonstrate honesty, integrity, and honor commitments. If we expect providers that we work with or case managers to honor their commitments in delivering services, the Department of Health needs to lead by example and honor their commitments to people with developmental disabilities and our various stakeholders. As I spoke earlier, we want to be open and honest in our communication. We want to partner in teamwork, share our expertise, learn from others who have expertise who are in the field, may have lots more expertise than us. We always want to treat others with respect, with dignity, with knowledge, honor everyone's different opinions and contributions, and to be a leader in the community and with different organizations. And always to promote good customer service. And that starts from the person who answers the phone all the way up to the Department of Health secretary. And customer service is also leadership. When someone calls our offices, that person answering the phone is a leader. They're the face of the department. So we want to make sure that we exercise good customer service and are responsive to the needs of our community and stakeholders. So division priorities for the state fiscal year 20, as we all know very clearly, our priority shifted as soon as COVID pandemic came into the picture. So our priorities this year, number one is the COVID-19 pandemic, the Jackson Settlement Agreement, and the supports waiver. My apologies, I lost the video there for a second. Sorry about that. Okay, so leveraging our partners, which I spoke to earlier in terms of being transparent and good communicators. Our partners very much include individuals in services, their families, their guardians, whether it be corporate guardian, mom and dad who is a guardian, or brothers and sisters. We partner with disability rights, DDPC and Alice and Pamela, who just been speaking to us this morning. They're very much a partner in our work with people with disabilities. And we also work with our people who deliver the actual service, the providers, the case managers, the therapists, and behavior support consultants, nurses. We are working really hard to establish a spirit of partnership with our community versus, directing things without input. We very much have been very diligent in seeking input as we are making our decisions. With respect to COVID-19 and how DDSC has responded to the pandemic, and so we've been in the pandemic since March now, so that's going on 6 months. Probably feels much longer to a lot of people. I know it does to myself. So one of the very first steps that we took in March under the leadership of Deputy Secretary Cornwell is we made the decision right away. This was right around the same time public schools closed, is that in order to mitigate the spread of COVID, the coronavirus during our population, we closed all of our congregate group day hab settings. And so what does that mean? That means any day program facility that provided services to large groups. Typically there could be anywhere from 10 to 30 people in a day hab program. So one of the very first actions we took was to close all of our group day hab settings. We also secured approval from the Centers for Medicare and Medicaid Services to allow some of our critical services to be continued remotely. So what is Appendix K? Appendix K is through the federal government, through CMS, the federal government allows states to submit emergency amendments to their waiver applications during times as a natural disaster, a pandemic or epidemic. And so COVID-19 is very much a public health emergency. And so when the governor authorized the public health emergency, we worked very closely with the federal government so that we could continue to offer our critical services, from the direct support staff to case managers to therapists to nurses. So some of those services continue to be remotely. We wanted to limit as much face-to-face interaction as possible at that time to slow the spread of the virus. We also work directly with the federal government to be able to increase our daily reimbursement rates to our providers. And why did we do that? Because of COVID-19, there's been an extraordinary cost to our provider network. Everyone's having to purchase personal protective equipment, from masks to gowns to gloves to face shields, having to pay overtime to staff, having to pay nurses for their increased supports. And so we were able to secure reimbursement to higher our rates specifically for those residential services in the DD waiver, our 24-hour supports. And we did that in an effort to support our provider community so that they can continue to operate, not only operate, but operate safely within the COVID-19 pandemic. Also, one of the major things that we did during this time is early on in April and May, DDSD mandated that all direct support professionals who work in the home, they must wear face masks. And so this was prior to the governor's announcement mandating face masks for the general population. We felt very strongly in working with our physicians at Department of Health and Epidemiology that wearing face masks was one of the things that we could do to really slow the spread of the virus, particularly in homes where you may have 4 individuals who live together, plus their support staff. So we did mandate that all direct support staff wear face masks throughout the entirety of their shift. We also mandated that the direct support professionals in our 24-hour homes receive COVID-19 testing. And so we were able to accomplish that through our partnership with our providers, and also a huge thank you to our partners at the Public Health Division who worked with us to not only set up the testing sites, but to work with our providers to test a large amount of staff in a relatively short period of time. And during that time, at any moment that a direct support staff tested positive for COVID, they were immediately removed from the home, and they would have to quarantine, seek medical attention as necessary. And again, we did that not only to protect individuals in our services, but also other staff who may work in that home. Also beginning in March, in the spirit of our earlier slides and talking about partnership, transparency, open communication, DDSD instituted weekly phone calls with our stakeholders. So we were holding weekly phone calls. For example, every Thursday we would host 3 phone calls with our different stakeholders, and we'll provide them weekly updates on DDSD's directives with respect to COVID. During that time, we issued 27 memos of direction, several supporting documents to individuals, families, guardians, and provider agencies related to COVID-19. And it was important for us to do these weekly updates because as we moved through the pandemic, we began to learn more about the virus and how it spread and how it impacted people as we moved further along in those months. And so we have been able to keep open communication with our partners, and we do believe that that has helped in terms of ongoing dialogue that we, in terms of decisions we made for COVID and any future decisions that we need to make. DDSD serves approximately 6,300 individuals between our DD waiver, ME-VIA waiver, medically fragile waiver, and state general fund programs. And so due to the efforts that we instituted that I've just spoken about, and not just our efforts, but I want to reinforce, the efforts, number one, of individuals and services, their families, their advocates, their support system, our providers, our other state partners. We were able to slow the spread of the virus throughout our population. And to date, as of yesterday, of the 6,300 people in services, 45 of those individuals have tested positive for COVID-19. And so, each of those 45 people, are very much a real person, have families, have support systems. And so anytime someone tests positive for COVID, DDSD works very closely with that individual's team to make sure that the necessary protocols are being put in place. Number one, that they are receiving the medical treatment necessary. We also make sure that other individuals in the home are safe from potential spread, as well as the direct support staff. Just a little bit more information. It's not on the slide about the 45 individuals who have tested positive. If you break down those 45 individuals, 10 of the 45 cases are in our metro region, which is primarily Bernalillo, Valencia County. In the Northeast, we've had one case. In the Northwest part of the state, we've had 15 cases of individuals test positive. In the Southeast, we've had 7. And in the Southwest region, which is, Doña Ana, Luna, Hidalgo County, we've had 12 cases, totaling 45 cases. And so that very much follows the trend of the state in terms of how the virus is impacting people. We've had the most cases in the Northwest part of the state. Second highest is in the Southwest. And then third would be followed by the metro region. Just a little bit more in terms of the 45 cases across all the programs. 38 of those 45 individuals who have tested positive for COVID are in the DD waiver. 7 of those individuals are within the ME-VIA waiver. We've had 0 positive cases in our medically fragile program, and we've had 0 positive cases in our state general fund program. So our next priority is the Jackson settlement agreement. I'm sure that most, if not all, members of the committee are very much aware of Jackson. Jackson is a lawsuit that was first filed against the state of New Mexico in 1987. So it is a 33-year-old lawsuit that continues to this day. There have been multiple orders, different variations of plans to disengage Jackson, whether that be the original joint stipulation on disengagement, the evaluative components when we had a monitor. Most recently, the department and the Jackson plaintiffs settled on an agreement. This was in April of last year, and that is called the Jackson Settlement Agreement. Within the Jackson Settlement Agreement, we have 10 areas that we must address in order to successfully disengage from that lawsuit. To date, between DDSD and our sister agency, the Division of Health Improvement, we have been able to successfully disengage 6 of the 10 areas. Give me one moment, please. And so 6 of the 10 areas in the Jackson Settlement Agreement, the areas are known as paragraphs. So when you see the word paragraph 7 or paragraph 8 in the slides, this is how they're referenced in the Jackson Settlement Agreement. And so to date, we have been able to disengage 6 of those areas. The first being with respect to incident management backlog. And what that means is anytime that anyone in any of our services passes away, they are subject to a mortality review by a committee that consists of DDSD, DHI, and the Human Services Department. And so there was a backlog of reviewing Jackson class member mortality cases. Because of the extremely hard work from the Division of Health Improvement and that committee, that backlog has been successfully eliminated. There is no longer a backlog of mortality reviews for Jackson class members. And so we've achieved that area. We submitted a motion to Judge Parker, who oversees the case, and he successfully disengaged that paragraph. Paragraph 8 is also related to mortality reviews, I misspoke. Paragraph 7 is incident management, not mortality review. So my mistake, I jumped ahead a little bit. Paragraph 8 is the quality of investigations from the Division of Health Improvement. And basically what that speaks to is that the Division of Health Improvement is conducting very timely and adequate investigations of abuse, neglect, or exploitation, and that has been successfully disengaged by the courts. Paragraph 10 is, my apologies again, this is the mortality review backlog that has been eliminated and disengaged by the courts. Paragraph 11 speaks to Jackson class members who have been deemed to be of high medical risk or high behavioral risk. They have significant medical and behavioral challenges. And in the settlement agreement, it was agreed that DDSD would increase their oversight of these class members through a variety of different ways, whether that's we would have to complete monthly nursing visits, monthly visits by our behavioral specialists, visits by our case management staff, and anytime they made a visit and they found a deficiency or an area that needed to be followed up on, they would follow up monthly. This is about 120 class members per month that are seen by the department. And we started this in April of last year, and we completed 100% of our visits every month to present. And Judge Parker was satisfied with that work and was able to successfully disengage that paragraph from the Jackson Settlement Agreement. The next bullet here is paragraph 14, which has to do with Jackson class members and employment and person-centered assessments. These are assessments of class members that identifies their interests and their abilities. All those class members of working age, we had to prove to the courts that they all have the required assessments, and those are being followed. And that paragraph 2 was disengaged by the courts. Finally, the sixth one, paragraph 16, there was language in the settlement agreement that the division needed to hire a national consultant to help us in the implementation of the settlement agreement, which we have done and continue to maintain. And so we were able to disengage paragraph 16 of the settlement agreement. Next slide, please. So what do we have left to disengage? Between DDSD and DHI, we have 4 remaining areas to disengage from Jackson. The first is related to mortality review. This is called paragraph 9. And essentially what the department has to do is prove to the courts that we are following our existing mortality review policy. And so just recently, I believe 2 days ago, the department, through our contracted attorneys, submitted a motion to the court asking them to disengage this area. We've submitted evidence of proof that we are in fact following our mortality review policy. So we're very excited that we have submitted that motion to the court, and hopefully the courts will agree with our position and order disengagement on this item as well. And so we have 3 areas left. Paragraph 12 basically says that the department must show that all of the class members receiving services are receiving their services in compliance with our standards. And we do have our DD waiver standards are approximately 285 pages, and there are specific health-related services within those standards. And so DDST needs to show, or DOH needs to show evidence to the courts that class members are in fact receiving health-related services. Paragraph 13 has to do with the agreements that we have with our providers. So we have contracts, if you will, with all of our direct support providers, case managers, therapists. And in order to disengage from this item, we need to prove to the court that we have an effective agreement. And not only that we have an agreement, that we are holding providers accountable.
Lunch. She has office hours now from 12 to 12:30. Okay, so let me make you a sandwich. Get on your slides for today. And
I'm sorry, Senator Lopez, could you mute your computer? Senator Lopez, thank you. Okay.
Thank you, Madam Chair, members of the committee. I will continue. I have children at home as well, so I certainly understand the challenges of working from home. So thank you. To finish up on this bullet, the last part, paragraph 15, is each year we have what is called the individual quality review, previously known as the community practice review, probably better known as the Jackson audit. And so one of our requirements is that each year there's a sample of class members who are selected, and they receive an audit to make sure that they are in fact receiving the services as designed in their individual service plan and in compliance with our standards. And from those audits, there's a series of findings and recommendations that DDSD is responsible for following up and making sure are addressed and closed. For the past 14 years, Lynn Rucker has been the Jackson Community Monitor overseeing this process. And so paragraph 15 talks about the successful transition from no longer having the oversight of a community monitor to allowing the Division of Health Improvement to independently perform that audit. And so we have not yet disengaged paragraph 15, but we have achieved a milestone, in my opinion. The Jackson audit has been successfully transferred to the Division of Health Improvement. They are independently implementing the audit, and so we no longer have the oversight of the Jackson Community Monitor. So that is a huge step for the department in moving us forward to disengagement. Next, I'd like to talk a little bit about the